And we're live, everybody. We're live. Let me hide this chat. I'm ready. I'm ready. I'm ready. I'm ready. So while we're waiting for this one, um, I was looking and this man has spent, and I forgot about that, but when he met Varya in Russia, he only told her about serving the 11 months for the drugs. He never mentioned anything about him serving time for stealing and that he was in and out of jail between 97 and 2000. So he never mentioned any of that at all. Um, and I don't know if you guys remember, but when he was talking to Varya's cousin, I think it was her cousin, and was it her brother, her cousin? I can't remember. But he said to him, do you know how many people that you've actually killed when he was doing the stuff that he was doing, you know, with the smuggling and everything? And oh, but he's so cocky and so arrogant. Come on, let's get this going. I just want to hear the sentence. So, whew, I just can't remember. She kept saying he dragged her through the house, kept slamming her head. So he's just he was innocent. He had all the evidence he needed to exonerate him. So let's see what happens here. I thought they might be going to lunch because it's 11 o'clock there. So, but I guess not. We're going to get this over with to put him out of his misery. Hi, Lily. Hi, Sassy. Hi, Sheila. Hi, Barbie. Hi, Tony. Hi, Quiet Bitch. Nuts and Board. April, Brenda, Teresa. Becky, you're back. Okay. All right, Becky. Sassy Nerd Girl, Stephanie, Angel, Amanda, Jennifer Positivity, Susan Dawson, Celia, Dorit. I'm not going to forget Dorit. I will send you all the info. The judge is getting ready to take the bench from the looks of it. They're zooming in and out. Hi, Barbie. Ashley Nicole, hi. Oh, Sarah, you are too sweet. Thank you. I love you too, sweetie. Um, okay, you work and just listen. Yeah, I was changing the time because I didn't want to have to restart my live stream. That's why I didn't want to go live until the judge took the bench. Hi, Tina. 103. Ooh, Saint Bernard. That's a big dog. Well, is that a is that a regular weight for a Saint Bernard? Okay, they don't have any sound on yet, so yeah, sound is on. Cry baby, cry baby, cry baby. Katie, Stephanie, Leanne, Oh, you don't have no snow in the UK. Okay. That's my work phone. Hold on. Okay. All right, I'm back. Scam call. Um, Come on, we waited since September, October. We waited. Come on. I'm actually in a meeting. I'm here, guys. I'm just looking to see what's going on. Okay. They're not doing anything. You're y'all stop saying I'm going to jail, please. Don't say that. You're right, Tony, and I agree with you on that. Oh, Terry, thank you. I don't know. I'm thinking with the act, you know what they say? They say that a sober mind, no, a drunk body speaks a sober mind. So I'm thinking he had all of this pent up frustration was with her. And that's why, hi, Sharori, long time no see. Yes, it's there. They're getting ready to bring him into the courtroom. So that's what I'm thinking. I'm thinking he had all of this stuff suppressed about what happened with his son. And but why then? I don't know. It's because she was on the phone and it was supposed to have said that she had cheated on him. We know she got married, what, 3 months after this? Um, People are speculating that she was cheating at that time. Maybe she just wanted to marry somebody to feel safe and secure. I don't know if she was cheating, but that's what the speculation was because she got married so soon after the incident. I'm not going to say incident, the assault. So, we don't know. And she didn't say why she got married 3 months later, whether she was seeing him or not. My understanding was it was an ex-boyfriend of hers that she had seen before Geoffrey. So I don't know. That Tony, you have some good points. I don't know what was the reason, but remember, he was seeing her and he was talking to Varia at the same time. So he was with her and talking to Varia. So what is that saying? Does that say he had ulterior motives? I don't know. Okay, so they're waiting for the courtroom. Okay. He had to, and that's what I'm saying. He had to. And if you remember, ooh, you're making some really good points, Tony. You really, really are. Yeah, it's actually under, I think it's under Geoffrey on the playlist because we streamed that whole second day. And I couldn't believe I stayed live that long. But we were commentating on the trial and everything. When they took lunch, we actually had we had commented, we had people come up to discuss what they were seeing so far. He is a very devious man. Ooh. I'm steady going for, so what do you serve? You serve, so for every 9 months is considered a year. I forgot how that works. Hey, Brookie, I forgot how that works, but I think it's every 9 months is considered a year. So if he gets, I'm still going between 12 and 16 years. If he gets more than that, I'm going to be shocked. Oh my God, Maggie. I remember this because during that trial and right after that trial, we had people to come up was talking about the abuse that they had encountered. We have a woman in here right now that told us how her husband stomped her teeth out with his steel toe, kicked her in the mouth with his steel toe boots. Yep, they don't need an excuse. If you're abusive, you're abusive. Yep, that's what she's been showing. Hi, Debbie. That's what she's been showing. She's been doing all of these videos when I could not, I don't understand why she had to go to his son's burial site. I mean, why she had to go to the cemetery and film it. For what reason? Why would you put that? Hi, my baby. Why would you put that on an IG live? Was that to try to garner some kind of sympathy from the judge? You've already been found guilty. Now we just down to the sentencing. That's it. 12 to 20. Minimum is 12, max is 20. And you're right. I would love, I'm sure she and Shelby seem to talk a lot. So, and I'm trying to remember if she said why they got, I know he started reaching out to her. She did not know he was filming. She did not know he was talking to Varya at that time. So it's just amazing. It's amazing how this man has gotten away with this, and he's gotten away with it a couple of times. And then we found out today he asked Brookie to come visit him. Oh, Debbie, how's okay? What's going on with your husband? Because I don't know if you guys remember, but Debbie was in the hospital for a while and then she was sent home. So she has a caretaker. Debbie, what's going on with your husband? Oh, Celia wants to 20. Yeah, I have never, ever been through anything like that, guys. And it's just, I remember when my first ex-husband, we had got into an argument and he actually raised his hand. And I remember telling him, I will let you hit me, but I will blow you the F away. And he looked right at me and he knew I wasn't kidding. I was going to shoot him right where he stood. And it wouldn't have bothered me. I would have put him out of his misery. Yes, he asked Brookie to come see him several times. Hi, Vixie. Oh my God, Debbie. I'm going to talk to you after this live. Oh my goodness. I'm so sorry to hear that. Varya is not going to talk to anyone unless you give her money. I had reached out to her before, and I've had Mary on a couple of times. Varya is all about money. No, it didn't. He thought he was all of that. Brooke, if you want to come up and give them details, girl, I'm going to drop this link. You can come on up and give them details. You let me know if you're at work, if you want to come up. Now, Brooke, if you were single, could you tell me if you would have went or not? That's what I want to know. I mean, he's a stud. I mean, if you were single, Brooke, would you have taken him up on that offer? That's what we all want to know. What in the hell is taking so long? He's got on shackles. Is the judge on a pee break? Okay. I'm dropping it for you right now. I want the details on this. Hi, Miss Amanda. Hi, baby. I want the details on this, Brooke. I really do. Yes, this is for his sentencing. I need the details on that one, Brooke. And people think that you and I are besties. I have never heard that one. Jesus, Geoffrey. There she go. What's up, 90?
Hey, hey, hey.
Hey, baby.
Yes, girl. This dude, I was trying to type it in the comments. I swear, I don't know. I told Rocco when this happened because I don't know if y'all remember Rocco, but Rocco and Jeffrey were really close. And I was like, oh my God. So at least I told Phil, but Lord, y'all know that we can't get anything from Phil as far as him verifying what I'm saying. But when I tell y'all, like, it was the weirdest thing because, we were talking. I'm a blogger. You know what I'm saying? We were talking
Yeah.
and we talked all the time, all the time, all the time. In fact, he gave me pictures. He gave me one picture. I should send it to you, Heidi, when I get off of here. I found
Okay.
it the other day. He sent me one picture and I didn't understand it. He was telling me he was going to give me, just like he kind of told mommy, like he's going to give me all this stuff whenever all this shit comes out. And he gave me a picture of him standing naked with his little boy. And all you could see is their butts by a trampoline And he was like, this is one of the pictures they're using to show that I'm egocentrical or some shit. But he was like, but Kristen took this picture. I mean, it was just like he would tell me things a lot, but then I wouldn't talk to him for a little bit. Then like all of a sudden he'd be like, he'd message me. I hadn't talked to him in days. Good morning, sweetie. I was just thinking about you. When are you going to come up here? When are you going to come visit? And I'm telling you, this shit, I'm all, like, hey, yeah, that'd be nice. I need a vacation, stuff like that. Because, I mean, what do you say? The guy knows I'm married and has children, and
I will
did
say,
not,
no, you little man. I'm not interested in you.
not interested. I'm your friend. And now you're asking me to come to Tennessee for the weekend. And it happened multiple times. Well, as things like, started going on and these girls started coming out of the woodwork, I met this crazy girl, and she was an airline stewardess. If anybody's been in the community, y'all probably remember her. But I mean, she was just, she felt like she was heartbroken. Like she was telling me how she was going to buy Jeffrey a car out of her 401k and all this other crap. And then there's this other girl that surfaced that said she went to his house and slept with him. And so I started thinking like, well, damn, he's asking me all the time to come to his house. He's got, now this other girl messages me telling me Jeffrey broke my heart and I was going to buy him a car. She's the same girl that fought over, never mind. We'll get into that later.
Yeah.
But anyway, and then that's when I called Rocco. I said, Rocco, what the hell is wrong with Jeffrey? Like, I was like, he has asked me, he's making me uncomfortable because he's asked me so many times to come to his house. He knows I'm married. I said, and now all these other girls are coming out of the woodwork. I said, what does he do? Invite different women every weekend to his house?
Yes.
And that is when I realized that's exactly what he was doing. It didn't matter.
You remember the girl from the UK? Oh, the judge is on the bench. Okay, do we have sign? Oh, the judge is there. We're getting to it, guys. I'm so excited. I'm sorry.
But I mean, it was insane. And I'm going to dig through my phone to see if I shot any of these screenshots. A lot of these were in voice messages. So I would have had to screen recorded the voice message. Most everything he sent me was in voice messages. And of course, y'all know that was my old account. So I have no access to those messages anymore.
He did that. I got the messages from the girl he was getting with in the UK, the girl from Mexico. Mr. Paschel, ooh, yep. Okay, we're on. Come on, where is he? Where is he? Okay, can we just see him? Can we just see him, please?
Heidi.
I'm so excited. Okay.
Oh, is that him?
This is the state of Tennessee versus Geoffrey Paschel. It's docket 116806. Mr. Paschel is here with his counsel. The state is represented by the district attorney general. Is the state ready for sentencing? Defense ready for sentencing?
President ready.
All right, General, call your first witness.
Your Honor, I think we have a preliminary matter we can take up before.
Sure. Yes, sir.
May it please the court, yesterday evening, we were given a email/statement from a potential witness at this sentencing hearing, Miss Allison Moon. Miss Moon apparently is a wife, and Mr. Paschel and she share a child together. It is our position that her testimony, she is not a victim under the Tennessee Human Rights Act. The state is seeking to introduce this testimony as an aggravating factor.
That's the ex-wife.
Is clear in the fact that it is not clear on the issue of criminal behavior. Basically,
Clear on the issue of criminal behavior.
well, we would cite the court to State versus Carrico in there in terms of determining whether it is an appropriate aggravating factor from the state. It has to be a prior criminal offense or constitute criminal behavior. The Supreme Court
What's the citation on Carico?
Carico is 968 Southwest 2nd at 280.
Should I have a copy for the court?
I want to see him.
Yes, that'd be helpful. Thank you. Thanks, John.
Okay. How come they're not showing us him? I mean, I see the judge, but I want to see him. Can we-
And at Carico, at page 285, the Supreme Court addressed the issue of whether being merely arrested or charged with a crime is not criminal behavior within the meaning of the statute. The court goes on to opine that the phrase criminal behavior has not been defined by this court for purposes of the enhancement factor.
Is he married?
The court further went on to opine that whatever the precise definition may be, sexual acts with a 10-year-old child clearly constitutes criminal behavior.
What?
When you juxtapose the holding or the dicta of the court in Carico versus the statement of Ms. Moon, it is clearly
What?
not subject
Wait
to
a
being an
minute.
aggravating factor that would be appropriate.
Did we
under
hear them say
Tennessee
he had
law.
sexual acts with a minor?
The statement,
A 10-year-old
Mark
boy,
Bishop
I'm
presented to
assuming
the
his
court
child.
Friday,
What is that?
the email that we received.
You've got to be fucking kidding me.
Ms. Paschel.
Get the fuck out of
Issues
No.
number one for ID only. What is the holding in Carico?
That the issue of criminal behavior.
No, Angel, it's Geoffrey Paschel.
It could be an aggravating, enhancing factor.
Get
because
the-
it was allegations of sex with a 10-year-old child.
Sex with a 10-year-old child. They said it again.
Holy
Oh,
fucking
yes,
shit.
Thank you.
No.
Holy shit. I don't have
This
any
is
words.
thinking. Oh my God.
So this is where they're trying to introduce this woman, his ex-wife, as a witness to go up to enhance his sentence
Go
to
ahead.
tell
Yep.
a story about him abusing his kid, a
In the
10-year-old
email
child.
marked,
Oh
as
my
Exhibit 1
God.
For ID, Ms. Moon goes on to relate a series of conduct that
Maybe
go
it's the
back
butt
to the year
pictures.
2007. Clearly, the allegations do not rise to the level of criminal behavior that would be an appropriate enhancement factor as set forth by the Supreme Court in Carico. There is talk that Mr. Paschel pulled her hair and frustrated her during her honeymoon, then alleges that he dragged her by the hair, squeezed her mouth. It goes on to have very obtuse, non-specific allegations regarding being forced to have sex against her will. Then she talks about certain acts that may or may not have occurred in Panama in 2009, some that may have occurred in 2010. She is across the board. And it's amazing that because of both the severity and temerity of the allegations, that there is no underlying evidence from the state to corroborate this information that we were provided last night at approximately 9:13.
Oh my
In
God.
fact, if Ms. Moon was permitted to testify, it would be impossible for us here at the 11th hour to render effective assistance of counsel and ensure that Mr. Paschel receives a fair trial pursuant to the 5th and 14th Amendments to the U.S. and Tennessee Constitution. The allegations took place in a number of cities, spanning a time frame of approximately 15 years.
Oh my God.
Some of the allegations took place out of the country in Panama. They are not as self-evident and apparent as the uncharged conduct that the Supreme Court addresses in Carico. So we would respectfully and vehemently urge this court to not allow the state to put in any direct or indirect evidence this conduct as it relates to an enhancing factor for sentencing.
I think
On
they
the
might be setting up
grounds
for another
that-
trial too.
This does not allege criminal behavior under enhancement factor 1.
Yes.
I'm just reading through this, and of course, I haven't heard Ms. Moon's testimony, but as I look at this, how are the allegations that are contained in this email not criminal behavior if they are proven by the state? It looks like allegations of domestic violence, holding her in a shower, hitting her with a belt,
Oof.
pulling her by her hair. There's allegations of rape in here. How is that not allegations of criminal behavior?
Well, if the court finds, I mean, I would say it's analogous to a 404B hearing where the court would have to find by clear and convincing evidence that the conduct occurred. But I mean, these, if they are used as an enhancement factor for sentencing, I mean, obviously this proof is very, I mean, we're going to ask for the minimum. Mr. Paschel. The state is asking for a sentence of 16
Oh,
years.
God.
I received, as the court can tell on the top of the email, this statement at 9:59 last night. I want to make sure it was that because it says AM. Okay. Well, regardless, I received it yesterday evening for the first time. I don't know if it was sent earlier, it was sent after business hours.
Is there authority that requires the state to give you that statement at all prior to sentencing?
Well, we would urge the court under the 6th, 5th, and 14th Amendments, one, to either disallow it or allow Mr. Paschel time to
So you
conduct
mentioned the
a
5th, 6th, and 14th Amendment. Let's start with the
substantive
5th
and
Amendment.
procedural due process. And
How does the 5th Amendment compel the state to give you this statement prior to a hearing?
Ooh.
At trial, you're not allowed to get jinx statements until after the witness testifies. So why in the world would the 5th Amendment require? the
No,
state
that
to
is
give
not
this to you
down.
Prior to a sentencing.
Under the 5th
He's gonna-
and 14th
he's gonna let this go
Amendments,
through. He's gonna let her talk.
Substantive and
Yep.
procedural due process.
He doesn't like him.
We have no time to investigate the conduct since we received it last evening at approximately 9:15.
Well, of course, those amendments, as written 200 and something years ago, don't say anything about providing witness statements prior to a sentencing hearing. So certainly, if there was authority that existed
Yeah, he's getting
that
a little.
required this sort of
He's getting a little
pre-hearing
nervous.
disclosure
Yeah.
by the state, there must be federal jurisprudence, state jurisprudence, somewhere saying this is what the 5th Amendment means, or this is what the 14th Amendment means.
Well, I think, to quote Justice Potter Stewart, I can't define obscenity or pornography, but I know when I see it, I know what a fair trial and due process, whether it's procedural or substantive, is. And basically, it's very simple. A due process analysis under the 5th and 14th Amendment in state and federal jurisprudence basically means that a defendant,
Get
a
another
citizen
lawyer.
accused, has the right to fundamental fairness. And the fundamental fairness is when you are looking at your liberty and at 9:30 at night, you get conduct that spans 15 years. And the only meaningful challenge I can make is to cross-examine someone on this statement. I think he's not given due process. There's a plethora of decisions in a variety of contexts and criminal jurisprudence that there is a requirement for fundamental fairness.
Sure, there's a requirement for fundamental fairness, but again, we've been doing this for over 200 years. I can't imagine if there was authority that compels the state to give this pre-hearing disclosure of a statement of this nature that would actually go above and beyond what the rules of criminal procedure would require at the trial.
I'm sorry.
There would be authority. There would be a decision saying that.
Well, respectfully, if you look at the Carrico case, they acknowledged that criminal behavior had never been defined by Tennessee courts.
Ooh.
And you would think that it would. I was shocked. I was surprised. Now, in that case, the uncharged conduct was related to the child abuse that everybody knew about during the course of the trial, apparently, or the investigation. I have
Yeah, that didn't
no
come up in the
idea
trial.
about Allison Moon that is talking about domestic difficulties that originated in
Domestic
2007.
abuse.
So, I mean, basically, here's the deal. An enhancing factor,
Here's the
court has
deal.
got to rule by preponderance of the evidence, whether they're applicable, not applicable. We have filed mitigating factors in this case. We filed them before. The state, during the course of this prosecution, has been very diligent and has tried to provide information to the defense. I don't know this, but I would
I
assume
don't see her.
that they received this kind of at
I
the
don't either.
11th hour. So basically what we're asking, and I'll boil it down to its simplest components. We've got information that spans 15 years. If we don't have the opportunity to conduct even a modicum of a reasonable investigation and it's used to enhance his sentence for as much as a day, this man will have been denied due process. The
No,
answer
he
is
is
simple.
not.
Exclude any testimony, any evidence or reference directly or indirectly to the Allison Moore statement or testimony. I mean, the record
Moore.
is replete.
I thought it was
We have
Moon.
The
Me
state
too.
filed a notice to seek enhanced punishment, and that's fair. We were able to then look at judgments. We were able to do some independent investigation, but and you ask about authority. If you look at Strickland versus Washington under the
Oh my
standard of
God.
failure as effective
Let the woman
assistance of
testify.
counsel,
She has a right to.
you don't have to be a rock star, but you have to be reasonably effective. And I'm telling the court, I can't effectively cross-examine Ms. Moore without investigating
Is her name Moore
any
or
of these
Moon?
allegations if it's used to
I don't know.
define, enhance.
It's been Ms.
my
Moon
client's
until
sentencing
now.
range. It's literally impossible. I don't know if there was a police report in Panama, in Florida. It says
Yes,
her
you're there.
mother or his mother looked aghast, had no chance to call, investigate, fly my FBI guy down to Florida. So we're not
Christy, I
trying
kind
to
of do
stall.
too.
But if the state can do it, enhance a sentence
I don't see her
in this
behind
manner
Jeffrey.
the night before sentencing hearing,
Okay.
then
Well, she's probably in there
the
then.
converse, what you're saying, show me some authority to say you can't do it. It's going to open.
Well, there's his
Pandora's
son right
box
behind
to
him.
Mhm.
Sentencing records that are replete with issues that, and it's hearsay.
Yeah, but that's not
Hearsay,
Paxton.
Innuendo, unproven
I don't-
conduct.
That's
Now,
one of them,
she
though,
came
right
from-
behind him, right?
Hearsay in. So
Yeah,
we
but
can-
Paxton
I'm not gonna let
is the one
hearsay
that
in. I'm
has
not
the
gonna let
straight.
irrelevant
That's not
evidence in.
Paxton.
So we
He's
can
the
go
one that's
ahead
married
and dispense with
with
that.
the baby on the way.
Right, but if there
The
was
baby
a
should be
number
here
of
by now.
orders of protection that we haven't seen, I would say I understand, I would go forward. I can read the OP, I can look at it, whatever. An email that someone purports to have specific recall for a period
We don't have
of
time today,
15
okay?
years, and also would have a
Right.
bias
Sentence. I don't
based
have
on
time
what
for all of
appears
this.
to be an acrimonious
Me neither.
history of domestic relations. That's something we would like to explore as well. But we think the answer is easy. One, due process is a fundamental concept that applies specifically to a variety of issues. And I would say the reason there's no authority, no one probably received an email from someone 15 years ago.
She already
wanting to
has
use that
her green
information
card.
as a sentencing enhancement factor under Tennessee law. Because it doesn't happen. Never happened to me in 33 years, where you find out at 9:30 at night that
I can't use the
there's
website. I
allegations
have
of
to use the
conduct that
streaming
occurred in
one
Panama
so I
a
don't get
decade
struck.
ago. So we would respectfully ask the court to exclude the evidence or conversely give us a reasonable time to represent 15 years worth of domestic issues that this witness is apparently going to testify about and the state is going to use to seek enhanced punishment.
Thank you, Mr. Isaacs. General?
Judge, first of all, just to set the record straight, I received this email from Ms. Moon yesterday during the day. I've not been holding on to it for a long time or anything like that. I then forwarded it to Mr. Isaacs and Mr. Emmons last night. It was late at night. I've been a little busy working, preparing for this sentencing, but just to set the record clear, I did receive that email yesterday as well. As far as the testimony itself, the state does believe that this is incredibly relevant to enhancement factor 1, and we believe that it's absolutely admissible as criminal behavior, as the court noted.
Yes,
We
they
believe
wanted to
that
bring
if
it into the
allowed to, Ms.
trial.
Moon would testify that for years she was the subject of physical abuse by this defendant.
Mm-hmm.
The Carrico case is pretty clear that, you know, you can't introduce facts related to the case itself to enhance a sentence. You have to introduce, you know, facts of other instances. The state believes that what Ms. Moon is going to testify to, based on the email that she sent, absolutely qualifies as criminal
Mary is
conduct
there too.
and is completely appropriate. And as the court noted, I am not aware of any authority that says that I have to provide the defense this written notice or this written statement, but out of courtesy, because we do work well together, I provided it to them last night. I will also note for the court that when we were first set for sentencing back in December, I notified defense counsel that Ms. Moon planned to come and testify, but I did not have these specific allegations from her. So I will just note that they have known she was coming, because that was the issue when we had to continue the last sentencing hearing, was because she'd already bought her plane ticket. So we do believe that this conduct is incredibly relevant to the issue of sentencing. It squarely falls within enhancement factor 1. And there's no authority that says that we have to give them this statement at any certain amount of time before she gets up and testifies. They will have the opportunity to cross-examine her when she's on the stand, and Your Honor will have the opportunity to weigh her credibility and give her testimony whatever weight you feel it deserves. So we would ask that you allow her to testify.
Okay, thank you, General. Well, as I stated, I am unaware.
So Varia is to where we're sitting. She's to the right of him. She's behind his attorney. And Mary is sitting over there as well.
A requires the state to
with her
witness list at a sentencing
She's away from her.
hearing
She's
to
like
the
6
defense.
people down from her.
And I'm certainly unaware of any requirement that the state provide any written statements of an expected witness prior to that hearing. It's not required at a jury trial. At a jury trial, the Jinx rule under our rules of criminal procedures simply require the statements to be provided after that witness gives the direct testimony.
Yep, he got more TV time.
I think the state is well within its rights at the sentencing hearing to put on any proof that is relevant to an
Yep, they're going to let her talk.
litigating
They're going to let her testify.
As I stated earlier, I'm not going to allow anything to come in that's irrelevant. I'm not going to allow anything to come in that is hearsay.
Boy.
But I think the state is well within their rights to offer this testimony, assuming it meets.
She wanted to testify during his trial. They wouldn't allow it.
So the objection will be noted for the record. And
oh, damn, Jeffrey. This ain't looking good, Jeff.
General, call your first witness.
The dirty deeds you do.
All right. Is the rule requested?
Yes.
Okay, if you anticipate testifying here today, if you would please step outside and wait in the lobby. And while you're out there, please don't discuss your expected testimony with anyone. Ma'am, if you come forward, please.
She's looking to see who the hell's about to talk shit. Who's about to out me for all the horrible shit I've done in the dark.
So 2 people are stepping out because they're testifying. Maybe it's the 2 women that wanted to. Remember, it was supposed to be 3, but they only allowed Christians because they didn't want to show a pattern of previous behavior. They
won't even. They sure do. They won't even uncuff him.
Your name for the court reporter, please.
Kristen Wilson Chapman.
Now, Ms. Wilson, you are the victim in this case. Is that correct?
Yes.
Okay, and we've all sat through the trial now, and so we know the allegations specifically that were brought out at trial, okay? I want to talk to you about some other stuff before we kind of get into that.
Damn.
So how long were you and Mr. Paschel in a relationship?
About a year and a half.
Okay. And prior to the incident that we had the trial for, were there ever any other?
I would object at this point. The state has acknowledged under Carrico that you can't have prior criminal behavior that's related to the same case. Those are the words the state just mentioned a few moments ago. I would object to any conduct that has been uncharged, not subject
yes,
to
Christian's pregnant,
notice, etc. So they can't have it both ways. She said
there's Wario. You see her now?
Yes. Carrico, it wouldn't come in. Then she gets
And
up.
Mary
the first
is over
witness
here.
Is
She's that way.
attempting to get criminal behavior in under the enhancement factor in the very same case. We would object.
I think what she was offering was conduct unrelated to the issue for which he was convicted.
Well, it's domestic violence related conduct, just like the court in Carrico
Hi,
said,
G_5.
prior sexual abuse allegations with a 10-year-old. It's not different. It's not separate. There was a confined period of time when these two were together. So we would.
So they're not talking about him doing anything with a 10-year-old, right?
Criminal behavior.
They have to be. What else are they talking about?
I think he's using that as case study in a confined. I gotta look this up. Damn.
It's the same case with the same general type of allegation.
See, same
Under
case,
Carrico,
same
we would
general
object.
type of allegations.
General?
Judge, I believe that this is exactly the type of evidence that Carrico allowed into court. The state is prohibited from seeking to enhance a sentence based on facts of the conviction itself. What I was asking Ms. Wilson is about prior instances of domestic abuse, of which she has detailed extensively in her victim impact statement that she sent to the probation office. So the defense has had notice of this. This is exactly what Carrico said.
Yeah, they're talking about a different case with a
criminal
10-year-old.
conduct. It
Yeah,
doesn't matter that
case
it
law.
is the same victim. These are
I got
prior
scared there
instances.
for a minute.
I'm not asking her about the offense for which he was convicted. This is completely separate, and it's completely appropriate under Carrico.
Again, if there is history of prior criminal conduct, that is relevant to enhancement factor number 1. So I'll note the objection for the record and overrule it. I will note that Ms. Chapman is in the unique position here. It sounds like as being a fact witness, but also being the victim of a crime, who would have a constitutional right under our state constitution to give victim impact testimony as well. So even as it relates to the events that were at issue in trial, she would be able to give victim impact testimony as it relates to those
That
events.
judge don't like him.
And of course, provide any other relevant testimony related.
Heidi, I'm gonna drop. I'm gonna be in the chat.
Mitigating.
Okay, bye.
So
Sorry.
again, not talking about the instance for what we were on trial on. I want to back up a little bit, okay? Can you tell us about the first time that Mr. Paschel was physically abusive to you?
We had been at a friend's house. Sorry. We had been at a friend's house for the day. On the way home, he reached over and grabbed
Thank you,
my hand
Trish.
like he wanted to hold it. And he took my pinky finger and bent it all the way back on my hand as far as it would go. We'd had a good day. We hadn't been arguing. I yelled that I was in pain for him to stop. He laughed it off, said it was funny. Him and his brothers used to do it to each other all the time. Didn't understand why I was upset. Yelled at me, called me a drama queen. And that was the first time that he ever physically hurt me.
Was that the only other time that he ever physically hurt you?
No, there were multiple other times.
Oh
after
my
that.
God.
What about
that. He is in 2019. It was in the fall. We went to like a brew at the zoo type thing. On the way home, he grabbed my hair while he was driving. I was in the passenger seat, and he grabbed a hold of my hair and pulled me over into his lap.
Oh, Geoffrey.
Just my head. He pulled me over and was trying to choke me.
I'm believing it because he's
And the
not.
only
Look
way
at
I got
him.
him to stop was by pretending like I passed out.
Look at him.
You think that was the incident that you noted in your addendum, in your victim impact statement? You think that was the incident in September of 2018?
Yes.
Okay.
He we ended up we were going back to my house, When we got back to my house, I jumped out of the car and I ran inside. But I had a keypad lock that he knew the code to. So he came in. I locked myself in the bedroom. He kicked the door in. He was physical with me, grabbing me, pushing me around. He broke my TV. He broke several things in my house. My some vases.
Do we have pictures?
Some mirrors, anything he could get a hold of, he was grabbing and breaking. He kept pushing me back down on the bed. He held me on the bed for some time.
I can believe that. He yelled at
I
Warrior's
talk
friends
about
on
an
TV.
incident from January of 2019 involving your phone. You recall that?
Yes.
Can you tell us what happened in that incident?
We were at his house, and he I found out that night that he had been talking to at least 2 other women. We had been dating at that point for a year. He had been talking to other women. So I took his phone and unlocked it and went and hid in the bathroom. And he was sleeping on the couch. And I was taking pictures of the messages on my phone so that I had proof that he had been cheating on me. At some point, he woke up. He came into the bathroom.
No, KK.
Saw what I was doing, ripped me out of the bathroom, took my phone, took his phone, threw me on the ground, took my phone and put it on the edge of the coffee table and smashed it multiple times and broke it.
Ooh,
I was
Jeffrey.
screaming because his sons were upstairs, and so I was trying to get someone to come help me. No one would come help me. I eventually somehow went out the front door. He pushed me over, and he has an electric fence that lines his driveway, and it's got rocks on the other side. He pushed me over that fence. He had my keys. He took them and he threw them out in the woods, so I couldn't get my keys.
God.
I had no coat. I was just outside laying on the ground in his yard.
So you said this occurred at his house?
Yes, this was at his house. There's a gate so that you can get out to the road. At some point, I did try to leave, and I told him that I was going to his neighbors to call 911. He told me that they were all his tenants. He owns several properties around his house. He said, no one's going to help you. And so I started just walking up the road.
When you described the first 2 incidences there, you said that you don't know what provoked it. Is that what you said?
No, neither of those.
Well, why did you keep going back to this abusive man?
His phone and I was taking pictures, but the first 2, no, completely unprovoked.
When you were in a vehicle on those times, right?
Mm-hmm.
Okay. And can you recall any other specific instances of abuse during the relationship?
Thank you to Conservative Guardian. They both need a polygraph.
That night that I left his house and I was walking down the road, he eventually, about 20 minutes later, pulled up in his car. He told me to get in the car, and I wouldn't because I didn't know what he was going to keep doing to me. So he pulled around me, pulled into a driveway, and I kept walking past that driveway. And when he backed his car out, he hit me purposely with his car.
Are you crazy?
Drove back to his house.
During any of these instances, did you ever attempt to contact the police?
One time.
I
I've been
did
gone.
in another incident, not that one specifically. That night I did end up finding my keys in the woods, and I did to get away. And I had slept in my car that night in a random apartment complex.
She shouldn't have to be up there talking about this. This woman is 9 months
the
pregnant.
Next time, this was right before the incident, so it must have been April.
Of 2019?
Yes, of 2019. He got mad at me over something. I don't recall what. He held me on the bed for a while, would not let me get up. And then it was yelling at me, but then it took his phone and he like smashed it into my mouth to like knock my head back.
Oh my God. Y'all must spend a lot of money on
I
phones.
still had my phone at that point. and use like the emergency SOS feature. If you hit your power button 5 times, it'll automatically call 911. And I used it and called 911. But once he realized what was happening, he snatched the phone from me. I didn't get to talk to anyone. He immediately hung up when they answered. And they did call back to that number, but he had my phone at that point, so he obviously didn't answer. And
So 911 actually called back.
Well, they
Yeah,
do
so
come
they
out
left a
too.
voicemail. I have the voicemail.
Oh my God,
Factual.
Kirsten, come on now.
I mean, I guess it depends on how she knew that they called. If that was through a hearsay source, it would be inadmissible. But if it was something
I
she
know.
personally observed, so
I
she wanted to
know.
clarify that.
She was away
How
from
how
him
do you
though.
know that 911 called your phone back?
They called and they left a voicemail.
That's not
I'm so
hearsay if
sure
they left a
that's
voicemail.
hearsay. It's not really a factual declaration being made by another person. I think this witness could testify based upon her own personal.
Okay, it's not crazy,
observations.
but if 911
911
calls
called her
back and goes to an
left a
answering thing,
voicemail.
wouldn't
We're
they
not
send
getting into
somebody
the
out?
contents of the voicemail or anything like that, just that they had called her back. So I think that is admissible.
And are there any other incidents that you can think of?
That's enough.
Not off the top of my head, no. That's all.
I want to talk to you now about what happened in June of 2019. Okay, what we're here for today. We went over your injuries during the trial, but I just want to kind of review that a little bit more. So, during the assault, did you lose consciousness?
Yes.
For how long?
About half of it, probably.
EMT
Few
said
minutes
that
at a
she had a
time here and there. I
concussion.
would come back into consciousness and then lose consciousness again.
Okay. Were you in pain?
Yes.
Can you describe
Really?
for the court how the amount of pain that you were in?
A lot of pain. He was hitting my head into the floor. That was the worst of it. Dragging me around by my hair and the holds that he had on my neck were very painful. When it was happening, remember thinking that he was going to kill me.
When you, after the attack stopped and after you'd been to the hospital and everything, did your pain continue for any amount of time afterwards?
Yeah, it got
Trish, I'm
worse. So I think
sorry.
at first I was kind of in a little bit of shock, like when I was
I'm
talking
so
to the
sorry.
police. But the next day and the day after that, like the pain really set in. My neck, I had neck pain for at least a year after the fact. Every day I would wake up with horrible neck pain that I had not had before that incident. So it got worse for the bit after.
And we all saw the photographs at trial.
Terry.
We saw the injury to your forehead.
Mhm.
How long was that injury visible like that?
It was, you could see it like black and blue or like yellowing for probably about a month. I had like built up scar tissue here that I could feel for several months after the fact.
And can you tell us, when you went to the hospital, what were you diagnosed with?
A concussion.
It's not hearsay. The
Can you
EMT
tell the
said it
court
too.
now how this whole thing has affected you?
I have a lot of anxiety and a lot of fear. Even with him in jail, it's hard. Every car that drives by a little bit too slowly. I'm looking out the front window. I fenced in my yard because I do not feel safe walking my dogs even around the neighborhood anymore.
Oh, poor baby.
My husband's not with me. When I open the door to let the dogs out, I scan the whole perimeter of my yard
Oh my
because
God.
I'm just scared.
Yep, because he's got
Is there
people that
anything
do
else that you want to tell the
supposedly
court
that do
about?
things.
About how this has affected you or anything else?
Not that I can think of off the top of my head, no.
I'll pass it, Mr. Judge.
Thank you, Jennifer. Cross-examination.
I wouldn't. I wouldn't. She's a pregnant woman.
Good afternoon, Ms. Wilson.
Good afternoon.
You talked about a number of instances of alleged abuse that occurred aside from the facts that were in the trial, the June 19th incident. If we could take those sequentially, you indicated to Ms. Good that there was an occasion where he had bent your finger back at a friend's house, correct?
It was on the way home from a friend's house, yes.
Okay, can you tell me the year that happened?
2018.
Can you tell me the day of the week and the month that happened?
Oh my God, come
I
on.
know it was in April because it was around Easter, but I don't know the day. Oh, it was on a Sunday. I'm sorry. It was on a Sunday. I do know that.
And it's true, is it not, that based on that incident of, quote, bending your finger back, you did not terminate your relationship with Mr. Paschel, correct?
So now it's her
We
fault.
didn't speak
Is that
for
what you're
about 2
saying?
weeks, but we did end up getting back together.
So the answer is yes, you did not terminate your relationship with Mr. Paschel, correct?
Ultimately correct.
You did not seek an order of protection from the Knox County Circuit Court, correct?
Correct.
You did not call 911, correct?
Oh my God, she said that.
Now, in September, you described an incident that was more involved, correct?
Yes.
Do you recall at what time, day of the week in September, those alleged events would have occurred?
It occurred at night, but that's all in September.
And is it your testimony that the allegations of striking, slapping, choking occurred in a motor vehicle?
Some of them in the motor vehicle and then some of them back at the house.
And whose motor vehicle were you in, Ms. Wilson?
Mr. Paschel's. He was driving.
And at that time, Mr. Paschel was driving the motor vehicle, correct?
Yes.
And it's your testimony today here under oath that Mr. Paschel struck, choked you to the point that you lost consciousness as he was operating a vehicle on a public street or thoroughfare?
We were at a stoplight on Kingston Pike.
Oh my God,
and
this man is
he
pissing me off.
was driving with one hand and he grabbed my hair with the other.
So the light had momentarily turned red. You're in a public street, obviously with a light traffic control device. That means there was traffic that flowed 4 different ways, correct?
Correct.
And you're saying that with one hand he's operating the car, and the other hand he's able to strike, strangle, choke, grab you by the hair?
He grabbed me by the hair and pulled me over into his lap and then held me there until I pretended to go unconscious. I didn't actually go unconscious.
Okay, so he's operating the car, and you're saying he's choking you to the point of almost unconsciousness at this intersection?
Yes, at the stoplight. The car was stopped.
And of course,
Oh my God, he's making it sound like it's her fault.
you have pictures of the marks? I
Really?
assume?
I did not take them, no.
And as an educated professional young lady, I'm assuming if the abuse was that severe, you reported it to law enforcement?
I did not.
I would assume that you contemplated seeking an order of protection where there would be specific findings and a court could make a decision on whether you were abused and set parameters of contact. Did you do that?
I did not file an
Did
order
you know what an order of
protection.
protection
Oh my
was?
God, listen to him.
You didn't.
Not at that time, no. I'd never been. in
He's
an
making
abusive
this worse for
relationship before.
Jeffrey.
And you're a school teacher and you have a college degree and you're
Oh my
telling
God.
this court that you didn't know what an order of protection was from somebody that had been the victim of domestic violence.
Not
Judge,
a domestic
just
violence.
testified that she previously had not been a victim of domestic violence.
This woman is
Well, this
9
is
months pregnant
2018,
and you're
so I
doing
guess,
this?
The finger incident, you didn't consider yourself a victim of domestic violence?
I don't know. I don't know what I was
Testimony
thinking.
was she had never been in an abusive relationship prior to that, is how I understood.
And the night where you indicate that Geoffrey Paschel was operating the vehicle and able to subdue, strike, and strangle you to the point that you malingered unconsciousness, Mr. Paschel had been drinking, correct?
Yes.
You'd been drinking, correct?
Yes.
So
And it
she didn't hit
seems
him.
like that is a common denominator as it relates to
Hi,
the
Cosmic Crazy.
allegations of abuse, correct?
Sometimes.
And the issue with the bent finger, it's true that you both had been drinking, correct?
I don't recall that day.
So you do not have a clear recollection of whether you had or had not consumed alcoholic beverages when you say that incident occurred?
I don't recall that day of the bending.
Oh, I didn't know
finger.
John
I
was
don't remember.
live.
All right, let's go to the next allegation that you've testified about this morning on June 7th, that Mr. Paschel took your iPhone and damaged the phone, correct?
Yes.
And
Exactly, Angel.
based on that, let's go back to the September 2018 conduct. After that alleged event, you did not terminate your relationship.
I didn't know,
with Mr. Paschel,
Amanda.
correct?
I did not.
January 7th, you say that he grabbed your iPhone, threw the phone, damaged the phone, correct?
He broke it over a table.
And at that point, once again, you did not call the police, correct?
I did not know.
You did not terminate the relationship with Mr. Paschel,
Okay,
correct?
Teresa.
I did not.
You did not go to the Knox County Circuit Court downstairs and seek an order of protection, correct?
No, I did not.
You did not.
Well, I
seek
can end my
a
live and you
for
guys can go, we can go
vandalism
over
and
there.
Damage to your phone, correct?
Correct.
And do you recall, Ms. Wilson, giving a statement to the Tennessee Department of Correction, Knoxville Office of Probation?
Yes. My victim impact statement?
Yes.
Yes.
And
Oh, I hate that attorney. He is a sleaze bucket, just
it's
like
true,
Jeffrey.
is it not, that even though you indicated that there had been other instances of abuse, you never detailed any of the
Maybe she's
information
seeing who he is,
in the
Teresa.
report
An
that
abusive
you're testifying
narcissist.
about here today, correct?
Okay, Becky, I'll stay here.
I'm not sure what you're asking.
Well, you never talked about bending the finger. You never talked about,
Okay.
none of those facts appeared in your victim impact statement, correct?
I'm not sure. I don't
Congratulations,
remember.
Naomi. That's my aunt's name. I'll stay, Teresa. I mean, Terry, I'll stay.
May I approach? Ms. Wilson, let me ask you if you can review paragraph 17, and it also continues on the back of the report, and tell me whether that refreshes your recollection.
Her hair looks like yours, Addie.
The only thing that I mentioned in here that we just talked about was taking my phone and car keys, so I couldn't get away.
That's kidnapping. That is considered kidnapping. What the hell? He's putting this. Look how she's looking at him.
And you testified, Ms. Wilson, about the injuries that you say you sustained on June 19th that were the subject of this trial, correct?
June 9th, yes.
And you would agree that
She doesn't have an attorney. It's just the
those
district
injuries
attorney.
were the objective evidence of the injuries was limited to the pump knot and the bruising and hematomas, correct?
From the pictures from the trial, is that what you're asking?
Yes,
Are those the extent of my injuries?
yes.
The pictures from the trial were the extent of my injuries from the June 9th incident. Yes.
Oh, Morpheus. Oh, of course he's there. I'm staying
And Ms.
culture.
Wilson, you are a intelligent young woman that obtained her college degree, correct?
Oh my God, what does that have to do with the fact that this man beat her to a pulp? I'm sorry.
School teacher, correct?
Yes.
And based on all of the information that you have talked about,
I want to
this
know that
morning,
too, Leanne.
there was nothing that rose to the level of you severing your relationship with Mr. Paschel prior to the allegations that were subject to this trial, correct?
I didn't know he was going to
We
stream
broke up
this.
several times throughout this, 2 weeks, 2 months at a time,
Thank you, Storm.
over the course of a year and a half, based on these different
Well, my question was,
events.
you never terminated your relationship.
But we did
with Mr.
eventually get back together. Yes.
And you would agree with me that there is one common denominator regarding these allegations.
Drinking? Yes,
Aside
he's an
from
idiot.
yourself and Mr. Paschel being present, well, there are two common denominators. One, aside from June 19th,
Ooh, she's in
there were no
Tennessee.
police reports, pictures, documentation, etc., correct?
There were pictures and he deleted them from my phone.
She said that in the trial.
There's no calls to 911, correct?
There was a call to 911.
And those, you don't have copies of those calls?
She said
I
he
have a
hung
copy
up when
of
they
the
called
voicemail
back.
that they left on my phone.
Jesus.
Do you have any other indicia of evidence of what you're talking about today?
No.
No orders of protection, correct?
Oh my God. Okay. Can I
Yeah,
just
other
jump
than
through
that
my
one
phone?
from June
I
9th.
mean, through my screen and just punch in my damn self. Seriously.
I have nothing further.
Thank you. Sit your tired ass down.
Ms. Wilson, why did you stay with Mr. Paschel for so long, even after the first incident of abuse?
He's very charming. And he's very persuasive. At first, the first couple of times it happened, it was crying, begging, please take me back. I am so sorry.
I can
don't
see
know why
that.
I did this. I want to marry you. I want to be with you. The later
While you were talking to
incidents
Varia.
that happened were threats. He told me, you will have nothing by the time I'm done with you. Your family, your friends, everything will be gone. And I was so brainwashed and so broken.
No,
at
I
that
wouldn't make
point
it.
that I just
I would have
completely
punched him
believed him.
square dab in his
I
face.
did not believe that I was worthy of anything else other than what he was doing to me.
Did you love him?
Yeah, I did.
Yep, that's true, Mimi. That's what my aunt went through. And her nickname is Mimi.
Ma'am, thank you.
Thank you.
Step down.
Her name is Patricia, but we call her Mimi. She went through that for almost 30 years. So here's the thing on the 10-year-old. They were using that 10-year-old as a case study to keep testimony out from the ex-wife, Miss Moon. So that's why they were
Yes,
referencing
okay.
that case,
Okay,
not
just in
that he
case.
abused a
Now, thank
10-year-old
you. I'll
child.
Make sure this is back.
He is doing his job, but I know. I understand he's doing his job, but the way he was asking these questions, she's already testified to all of that. And I know he's trying to get him off of the lighter sentence, but the minimum is 12 and the max is 20. He's not helping himself right now because the judge is not happy with him or Jeffrey. And here we got the new woman coming up to testify. Is that Moon?
Truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Please have a seat.
Can you state your name for the court reporter?
Allison Moon.
Moon,
you
dummy
know
attorney,
Jeffrey
not
Paschel?
more.
Yes, I do.
And how do you know him?
I know him because I was previously married to him.
When were the two of you married? What were the years?
We were married
Beautiful.
I met Mr. Paschel in 2006, late 2006, and shortly after that, we got married, and we were married until mid 2013, roughly.
About 6 years you were married. Okay. Do the two of you have any children together?
Yes,
And how many?
we had one.
Okay. And how old is it boy, girl?
It's a boy. His name is Crusoe, and he is 10.
And you know why you've been called to court today.
Absolutely.
And you know that Mr. Paschel has been convicted of several things related to Ms. Wilson, correct?
Yes.
I want to talk to you specifically about
Jennifer, I
some
hope you get
things
better.
that happened during your marriage to Mr. Paschel. At any point during your marriage, was there physical abuse?
Yes, there was.
And if you could, to the extent that you can just kind of recall it off the top of your head there, can you just tell us about specific instances that you remember?
Sure. Early into our marriage, a couple months in, there was definitely verbal and emotional abuse.
Your Honor, I would object. The enhancement factors talks about prior criminal offenses or criminal behavior. Verbal domestic arguments would not rise to the level of satisfying the enhancement prong under Tennessee law and would not be admissible or appropriate. So we would object, move to strike, and ask that it be excluded further from this.
I'm sorry, guys. I have to. I'm working and doing this.
Just, I will just ask her about the physical abuse. However, if there were instances of verbal abuse where you felt like you
Object
were
to
being
her talking to the witness. If she can ask the question and allow me to object.
Okay, here's how I'm going to rule. I'm going to sustain the objection in part with a clarification. We don't need to hear about verbal altercations. The general is aware of our state's assault statute and how certain verbal behavior could rise to the level of criminal activity. You guys are well aware of that. I will allow that type of evidence, but otherwise, the general can just remain focused on questioning regarding specific instances of alleged criminal conduct.
Yes, Judge. And so with that, can you tell us about any physical abuse or were you ever put in fear by any verbal abuse?
Absolutely. There were many threats made to me and to my family. He was violent to me on numerous occasions.
And I'm going to stop you for just a second. When you say threats, what kind of threats?
To kill me,
Oh,
to harm my family,
oh.
and one of the last physical altercations that we had was I was arriving home after spending time with my cousin, with my son at the time, and he didn't believe that I was where I said I was, and showed up at my home, grabbed me and threw me into the bathroom, closed the door, told me not to leave. There would be consequences. He took Crusoe and put him in the car and left. He had taken my keys along with that.
He likes things with keys, huh?
Sitting there for a little while, I opened the door and quietly came out. He wasn't in my house anymore. Happened to find, I found my phone and contacted him to make sure my son was okay. That was my primary concern. Shortly after, he came back to my house, and nowhere in sight was my son, but he immediately attacked me and grabbed me and shoved me into the wall, threw me on the ground, strangled me. When I finally broke free, he went and swung at me, and I moved so he could hit the top of my head versus my face. And after that struggle went on for a good 20 minutes, I finally was able to plead for him to stop. I asked where Crusoe was. He went and got him out of the car. He had been in the car by himself the whole time.
How old was he at this point?
He was a year and a half.
Oh my God.
And
Yes. Very narcissistic.
he hung around and knew I was mentioned that Crusoe had to be put down for a nap, so he hung around for that. After that, he pulled me into our bedroom and started taking off my clothes. Was wanting me to have sex with him.
Oh, Sarah, I don't see
scared
where she
that
hit it, but we're
I
sorry.
resisted, that he was going to become violent again. So I just let it happen.
Objection, that's not criminal behavior.
I'll be the one who determines. what
Thank
criminal
you.
behavior
You're
is.
not the judge.
I think that's relevant. She's describing these attacks. We can't pigeonhole her testimony.
Sarah, you can
into
put your comment
the
back in, please.
very small confines in which you're wanting to do this. If we were trying this case at trial, for instance, this would all be relevant to show the circumstances surrounding this alleged conduct. So the objection has been noted. We need to hear what this witness has to say. General?
Were you done with that, sir?
No, so when he was forcing me to have sex with him, I was in pain. My back was
Oh
hurting.
my God.
It was just when he was grabbing
I'm gonna mute
me
for a
and
minute. I gotta
the
make a
force of
call.
it, I was just, it was very, very painful. And then it was over and he left.
Hey,
and then
Cindy,
shortly
could you
after
rerun that report
I
again, please? Because
had a
Darylyn
friend
just
come over
updated
and help me
the
pack up my
Herbatox because she
things.
didn't have the full,
And one day, and then I
the
took
full
my son and
Herbatox
myself,
forecast.
and we moved
Could you
to
rerun
Florida
it and
to
send
live
it
with
to
my
and
parents,
send it to
and
Katia right now,
that
please?
was the last of the violence.
Okay.
I want to
All
talk
right.
to you. You
All
were
right,
in the
go ahead.
courtroom when we were talking about the email that you sent to me yesterday.
Yes.
I want to talk to you about some specific incidents that you listed.
Oh,
in
I thought I
here.
was muted. Sorry.
She asked her, I think she just testified that was
Sorry.
the abuse. And so now she reads from the email one that's leading, and I think it would be appropriate to use that. I mean, she's seeking to, I guess, introduce a prior consistent statement.
As I took Ms. Moon's testimony, that was the last incident in time before she left Mr. Paschel. So if what I think is happening is that the prosecutor is referring her to incidents that occurred before that. So, of course, the state can't lead. I don't think she was leading. I think she was just directing her to other incidents. So I'll note the objection, Joe. You may ask.
Can you tell us about the first time that there was physical abuse?
Yes, 4 months after we were married, we were having a conversation, and it was not long into our marriage, I began to question his fidelity and whether he was maintaining loyalty and being honest with me about things. And so when I brought it to his attention, he would often get defensive and start to make me think that what I was saying was wrong, or that I was crazy for thinking so. And the first time I had said something, and it just immediately snapped, like no warning. He jumped on me and held me to the ground, but had his hand over my mouth, just squeezing it, like, hey, stop talking, basically. And after that first time, he was extremely apologetic and promised it would never happen again, and wanted this marriage to work out. And I believed him. After that, though, there were many instances of increasingly more violent things that he did to me, such as strangling me,
Oh
holding
my
me on the ground
God.
and strangling me. and dragging me by my hair, backhanding me in the face. He's elbowed me in the back. And each time he would be threatening me and I didn't believe I could do anything about it, because oftentimes my phone would have ended up broken in the course of our arguments. My keys would go missing, or he would have him. And then he's often disabled my car before, so I couldn't leave even if I had the means to leave or get help. Where he lives in a rural area, it would take me a long time to get out of the house and run to a neighbor. So I felt very isolated. Slowly, from the beginning of our relationship, I became estranged from friends, and it became more and more of a fight to see my family. Financially, I didn't have the means to go and get away from him. He made me dependent on him. But yeah, it went on for a long time.
Did you ever call the police during any of these instances?
I did one time.
Can you tell us about that?
So there was a time in our marriage where we were separated. I lived in Florida to go and get my master's, and he showed up unannounced one night. And this was during a period where things weren't going well in our relationship, since it was a roller coaster throughout our whole marriage. He showed up unannounced and walked in through my back door at my parents' house. And I was startled because I wasn't expecting him. So the first thing I did was hid my phone, because the typical pattern is you'd take my phone so I wouldn't have means to contact anybody.
The phone and the keys. Okay, Jeffrey.
When I came back, I found him in the kitchen, and he got close to me and was talking to me and trying to smooth talk me. And then before I knew it, I had been like backed into my bedroom. And I remember him forcing me onto my bed, and he started touching my private areas and telling me we're going to have sex. And I didn't want it. I was telling him no. And I was able to wiggle free. I ran out of the back of my house, knocked on my neighbor's door, rang the doorbell several times, and he had come out of my house and left. And I went inside and locked all the doors and called 911.
And so you actually did make a police report that time?
Absolutely, yes.
And you described all of these events?
I did make a police report, but I didn't follow through with charges because I was so afraid of what he would do if he would come back and do worse.
I can see that.
He was unpredictable.
But you're speaking up now. That's the best thing.
In 2010.
Yep, control freak, narcissist.
Tennessee.
And you said that this sort of abuse was kind of happening throughout your entire 6-year marriage.
Yeah, it came in cycles. We would be okay and things would seem normal, and then with little notice, he would snap, be in like a fit of rage. There were always arguments about, if he was telling me the truth. I was always very weary, but everything would always be unpredictable to what would happen next. And I would leave. I've left numerous times, but he had an extra key to my car and would come and take my personal belongings out or disable it so I couldn't go anywhere. So
my ex did that to me once, disabled my car.
Relented to what his demands were or what he wanted, which was usually for me to come back and promising me things were going to be okay.
So I just bought a new car.
2 months later, the cycle would begin again, and there would be an argument that would lead to him being violent, and I'd be right back wishing I had left or could leave, but always felt like
He'll be 61 when he's released.
Judge, I'll pass the witness.
She looks like Mary a little bit.
Good afternoon, Ms. Moon. My name is Gregory Isaacs. I represent Geoffrey
And Mary knows because
Paschel.
they had an altercation.
You and Ms. Wilson are friends, correct?
Yes,
You talk almost on a daily basis.
What does it have to do with anything?
more of a weekly basis.
And in fact, you have an ongoing domestic civil case against Mr. Paschel, correct?
I do not have I have a domestic case. Yes, it's child custody
That
related.
you hesitated. There is a pending civil litigation where you are the petitioner, he is the respondent,
It's
correct?
actually been resolved. That's my understanding.
Ooh,
Now, there might be a new motion for something else, but
And in fact, Ms. Wilson
Shut him up.
in that case testified on your behalf, correct?
yes,
2.
And you and Ms. Wilson have talked about your testimony here this morning, correct?
no, not my testimony this morning.
Well, you've talked about your testimony, correct?
We've shared experiences together, but that didn't begin until after 2019.
Okay.
And
If you could please answer my question.
Judge,
She just answered you. No.
ask Mr. Isaacs to stop kind of being a little hostile towards this witness. She is in fact answering your question and getting a little hostile with her.
And I see a little bit of Mary in her
Let
too.
Ms. Moon give her answer and you ask your next question.
The judge don't like you.
Ms. Moon, I apologize if my demeanor is hostile, but Your Honor, you're a hostile witness. You're adverse to Ms. Paschel, and you never talked about in direct any of this information regarding your relationship.
The
with Ms.
record,
Wilson.
let me clarify something here. Miss Moon, as far as I can see, is not being a hostile witness.
No, she's not.
It's a legal term of art.
It is a legal term.
She is answering both parties' questions, I feel, to the best of her abilities. The court is not finding her to be a hostile witness. I just want that to be clear in the record. Go ahead, Mr. Isaacs.
When did you last speak with Ms. Wilson about your testimony here this afternoon?
the last time we spoke about it had been within the coming weeks of being here.
And in fact, you wanted to testify so much that you actually have come here from out of state, correct?
Yes,
And Ms. Wilson asked you to come here, correct?
Exactly.
there was no question of her
Re-victimizing
asking
them.
me to come here. I was going to be here to support her.
Well, let me ask you this. Can you relate to me the substance of your conversation with Ms. Wilson about what your testimony was going to be this morning?
Yes, he
We
was.
discussed that
Angel.
we were going to be sharing our experiences that we endured while with Mr. Paschel. That was it. Though not in detail because there was no need to at that point.
Well, why would you feel the need to talk to Ms. Wilson about testifying on behalf of the state truthfully regarding these allegations that span over 15 years? I mean, they're 15 years ago with the 6 years you were married.
Because we were friendly and we're friends and we've endured similar experiences, and it's through a means of support to one another to know that she's not alone.
And would you agree with me that both you and, well, let's not talk about Ms. Wilson, that you don't like Mr. Paschel, your ex-husband, the father of your 10-year-old Caruso, correct?
I don't have any feeling. I'm indifferent to him. He means nothing to me either way. I don't spend a lot of time thinking about him.
So if I recalled Ms. Wilson to the stand, she would say that you've never had disparaging conversations about
Of course
Mr.
they
Paschel.
have.
We
Shut
both
up.
agreed that he was a very
Abusive.
harmful man.
So my point is, you both have a bias against Mr. Paschel.
You beat this woman.
Yes, we definitely do.
Oh my God.
Believe our experiences warrant it.
Yes, it
You
is.
have not only a bias, but a very strong bias. Correct, Ms. Moon?
I
Yes.
endured several instances of violence
Yes, her
with this
too.
man. Of course, I have feelings of dislike toward him, but I don't dwell on it. Or most of the time, our conversations over the couple of years we've talked to each other have been about our lives.
And let's talk about these allegations. Now, you, are you employed
Yes,
what's your?
None of your business.
I'm a teacher. I'm a 4th grade teacher.
Okay,
Oh, they
you're a
got that in
teacher.
common.
Obviously, you have a college degree, correct?
Yes.
They have that in
And
common.
you know that there are resources to help people
Oh
if
my
they are in
God.
fact involved in an issue of domestic violence, correct?
Absolutely.
And when many of these allegations allegedly happened, you were residing in Florida and Mr. Paschel was residing in Tennessee, correct?
For half of our relationship, for 1 year of our relationship, we lived separately, or year to 2 years. The first 3 years of our marriage, we were living together. And many of the altercations happened during those 3 years. They got increasingly violent over those 3 years. When I came back and after I had my son, that's when I experienced the most violence from him.
All right, let's get this straight. One, for the 3-year period, no calls to 911, correct?
No calls.
He is a
911.
dumbass
So we
attorney.
can't tell if you ever made a complaint of
See if
domestic
he has on
abuse
white socks.
or if there was an escalation of domestic abuse, correct, as it relates to 911 calls.
Correct.
There were no criminal warrants taken out regarding this conduct, which appears to constitute assault, battery, strangulation,
Yes.
false imprisonment. No warrants. Never
Right.
sought to have Mr. Paschel.
Yeah, he's pissing the
correct?
judge off and everybody
No, I
else
was
too.
in complete fear of doing so
Mhm.
with the threats he had been making to me leading up to these physical violent altercations.
Never once sought an order of protection.
Oh my God, here
Or
we go.
what? He could still come after me. He
Yep.
had a copy of my key. So no, I didn't believe I had the means to do so and be safe from this individual.
All right, so for the first 3 years, you say there was abuse, and instead of running, instead of calling 911.
Oh my God.
order of protection, you had a child, correct?
And I didn't have the means to call 911. I didn't have the means to leave the house. He had my keys. He would destroy my belongings.
Or if you could answer my
So
question.
no, I didn't.
She already answered
Did
your
we have
damn
a
question.
child
Now you're
to make
pissing me
our
off yet
relationship
again.
better?
Yes, thank you. Does it matter?
I mean, there's no telling. Did I think it would help? Perhaps, but honestly, because he would describe to me that would make a difference.
Yeah, he had on white socks at the trial.
After 3 years of this alleged abuse, instead of asking for help, you decide to start a family with Geoffrey Paschel, correct?
Yes.
And you started.
He's an abusive man. I want to talk to his wife.
Because you think, or you thought, he would be an appropriate father.
I was
Correct?
hoping he would be an appropriate father.
So.
Thank you, Angel. They don't.
If you thought he just continually abused, slapped.
My cousin had one and she wound up killing her
that's someone
husband.
you would have planned a family and have children with, if that's true, correct?
After being several years outside of our marriage, no. Back then, my head was not clear. I was filled with the threats and the fear that he built, the criticisms,
Girl, you go ahead on,
Constant-
Tater Tot.
harassment. He did nothing to make me believe that otherwise.
Thank you, Terry. We saw the
And
pictures.
This abuse and this brainwashing was so severe that you never called 911.
There we go again with the 911. She did call 911.
But yet you started a family with Geoffrey.
Yes, I did. Though I didn't have the means often to get the help I needed when I needed it. Because after
Thank you.
after this storm, it was calm and I thought I could.
We could all
believe
ride
things
together,
would
shit.
improve, and they never did, and it was a vicious cycle that.
Okay. Now, you were married to Mr. Paschel from 2006 to 2013.
Oh my
Yes.
God.
And there has been a variety of very acrimonious civil lawsuits, pleadings, motions, contempts, etc. Correct?
It's not a plot. It's not a plot. He's an abusive,
Mhm.
narcissistic
Between you
ass.
and Mr. Paschel.
Sorry.
Yes, regarding child custody.
And it was and is a hotly contested issue in circuit court, correct?
It was concerning based on his continued criminal behavior and repeated actions.
Thank
that
you
kept
for saying
happening with
criminal
other women.
behavior.
So yes,
Well, let's talk about what happens today. The longer the sentence that Geoffrey gets, that helps you in your custody battle with 10-year-old Caruso, correct?
Crusoe already did not have a relationship with his father for the last 5 years, so it wouldn't make a difference to me today.
Well,
Ooh.
you a petition to terminate Geoffrey's parental rights, correct?
Correct?
Correct.
So you have other motivation than the abuse that you never told anybody about.
Oh my Lord, this
Justify
is.
adversely to Jeff Paschel today, correct?
Ooh.
I have motivations to do
I
what
just
I
want to
think
eat
is
him up.
right by myself, by my family, by the women that he will continue to be a predator to.
The women, so you represent the women that's.
It's
like
not
you?
relevant.
No.
It's not
I'm
helping
saying
his case at all.
directly, I know I'm not one. Clearly I'm two, one of two, and there's other women
Thank
that
you.
he's been involved with that
Oh, thank you,
that
Naomi,
have
for the super
endured
sticker. Thank
violence
you.
by him.
How do you know that?
Because I've seen court documents that state that from other people he's married to.
And y'all talk.
You can swear,
correct?
Rebecca. Go ahead,
That's right.
swear.
I've
Talk-
never
you
had a
talk to Ms.
conversation
Wilson?
with his most recent wife.
Well, let's talk about this period that you were married from 2006
Oh, my
to
Lord.
2013.
He said he didn't have time to prepare, right? But
You
he seems
talked
to have a.
about issues of
Yeah,
abuse
okay.
that happened in Tennessee and then issues of abuse that happened in Florida, correct?
Yes.
Can you name a single date and time that one of these alleged events occurred other than the nebulous 6-year period?
Nebulous. Ooh, he used
A single
nebulous.
date or time.
What about
if you are
nefarious?
indelibly
What about all of
etched
those
in your
words?
memory that they occurred.
I mean, I can
Yes, the
remember
mods can
months. Dates
swear.
are a
Today.
little bit more challenging to pull, but I know that, gosh, when he showed up at my house, I believe it was August 28th or 29th of 2010. I know the last violent act that I recounted was August 2013. It was
12:45.
within the
Come on.
first weeks of August.
I have 2 hours.
But
For my
remembering,
next
I don't know how remembering a specific date is important. It's been a long time.
Everybody can
Clearly
swear
these
today.
Memories stick with me, but I don't remember the specific dates of many of the encounters.
Well, let me ask you this.
I love you too, Sue.
This is so severe and so pervasive. You can't even tell the court the day of the week or the date that it happened?
Oh my God. Shut
Again,
the fuck up.
with time, it leads my memory to be fuzzy on specific dates and times.
So yeah, he
I
wants you to give a
often in the-
specific date
in
so he
the
can go,
midst
you're
of-
lying.
Being abused, I'm not going to refer to a clock so I can remember in the future. and
Thank
tell the
you.
court what time something occurred. It just doesn't.
No medical records provided to the prosecution of abuse?
No.
Absolutely nothing to corroborate.
Oh
the
my
story,
God.
correct?
Correct.
Just you and Ms. Wilson talking on the phone week after week, and you representing all those women to light Geoffrey up in criminal court, correct?
I have said in court documents prior to meeting Kristen.
Thank you,
my
Storm.
experiences
Extra
with
time.
Mr. Paschel. So this is not new, as in me talking to her and coming up with a story.
Let me ask you this.
Oh God.
The state has represented that you sent in this email yesterday, correct?
Yes.
That's what they said.
You knew the hearing was today, correct?
Yes.
Yep.
And so you chose to give them all this information of abuse, knowing that.
Nope. They
my
knew it before.
investigators, my office couldn't investigate it, correct?
Judge, I can interject here. I specifically asked her to send me this yesterday, and that's what she did.
Then I will withdraw the question.
Thank you.
I have nothing further.
Very briefly, Judge.
I would have lost it. I really would have. She did better than I did.
How did you and Ms. Wilson begin communicating with one another?
I received her police report in the mail from my lawyer
Okay, and
in August of 2019.
did it contain her phone number?
Yes,
Did you reach out to her first?
yes,
And was this before or after the June 9th of 2019 incident?
after.
Okay. And prior to coming into court today, did you and Miss Wilson get together and say that
Damn,
you're going to
sassy.
testify one way and she's going to testify one way? Did that ever happen?
Definitely not in that way. No.
Okay. And like you stated, the allegations that you're talking about, this is not the first time that you've been in court and stated these allegations.
Correct.
You pled them actually in many of your custody
Yep.
documents.
Yes.
Custody documents that Mr. Paschel received.
Yes.
Yep.
Nothing further, Judge.
So this is nothing new.
And in fact, Ms. Moon, you really were not as scared and frightened of Geoffrey as you're saying today, correct?
Oh my God.
Absolutely.
Well, you were so not frightened and so comfortable that in
That you had a baby.
2013, you agreed to give him 50-50 custody with your son Caruso.
Yes, I agreed to 50-50 custody up until the age of pre-K, where he would begin school. So in my mind, if I could come to an agreement with Mr. Paschel without there being threats and
Yep.
further violence, then I was going to try to be amicable and do that.
So you have somebody that you describe and you're still describing as violent,
Oh my God.
unpredictable and whatever, and you agreed to let him have Caruso 50% of the time, unsupervised, no parameters, correct?
Correct. And I was doing that in hopes that he wouldn't do something to hurt my child or for my child not to witness further domestic violence with other women he brought into the home. And
Well, let's not talk about other women. We talked about that before, but isn't it true that you or any mother, if all of this violence was true, would never hand
Object
their
to object. Just
Well,
asking her to speculate what
so-
other mothers would do.
What?
Sustained, you can rephrase the question.
I don't think I have anything else to ask this witness.
Thank you.
Ms. Moon?
General,
Nothing further.
Ms. Moon, thank you for being here today.
Ms. Moon, subject to recall.
Who's he recalling?
Courtroom if you'd like.
Ms. Wilson?
Yes.
What the hell? This man's an idiot. Okay, can we see if he has on white socks? Yep, because of lawyers like him. My aunt was in an abusive relationship for a little over 30 years. Never told anybody. Can't see his socks today. Shit.
Before the state calls the next witness, we do need to take about a 5-minute recess. If you anticipate being a witness in this case, as we've discussed, do not discuss your anticipated testimony with anybody until you're called into the courtroom and sworn. We'll be in a 5-minute recess.
Okay, we got a 5-minute recess. So they're not even going to go to lunch. They're going to get this over with. So anyway, this guy's an idiot. He's the biggest idiot I've ever seen. And I'm going to agree with, I forgot who just said it. His tactics didn't work the first time around. So let's do it again. Let's re-victimize the victims all over again, because Geoffrey is an angel and a saint. And I understand that Varya is sitting there staring at him. She's probably going, what a fucking idiot I am for even believing that you were not this abusive, narcissistic jerk. Because if she's not, she needs to be punched upside her head. And I want to know how Mary feels sitting there hearing all of this stuff again, because she knew about all of that with his ex-wives and his, so she knew. So this should come as no surprise. This is crazy. And her stuff has been documented. I had her documents from all of these different trials and stuff they were going through. And it's in my other laptop because I had those documents. He's an idiot and he's disgusting. He deserves 30 fucking years. Shit, he deserves life. He don't even deserve to come out. I can't believe that. They're re-victimizing these women all over again. Oh, I just don't get it. I don't like him. I never liked him, ever liked him. Okay, let's see. I was trying to put all you guys' comments up. You guys have got some great comments. Yep, they're both idiots. He's guilty. He's already been found guilty. Now we're going through. Why can't we just sentence him? Well, I know we need the victim impact statements. I get that. But why do we have to let his attorney talk? Why don't he get somebody else to talk instead of that guy? Because somebody keeps calling him Igor. Yep. No fake crying, none of that. They were sincere, they were strong, they were straight up, and they were looking directly at him and at his attorney. Oh, Terry, I'm so sorry. Oh my God. Did he get any type of prison time or anything? They both did great on the stand. And Kirsten is 9 months pregnant, and you're putting her through this. This shit is crazy. And Geoffrey's sitting there. I want to know what he's thinking. Because, while they're testifying is great. If I was able to stream it directly from Court TV on TV, I would. But I could only stream from the link they give me in StreamYard. I would love to see the look on his face. And I want to get a good look at Varya to see what the hell she's thinking, being with this piece of shit. Yeah, I'm going to grab me a salad real quick. It's already in the refrigerator. But you know what? I don't know if he did anything to Varya. See, here's the thing. If they offered him this deal with no jail time. So he's thinking he's not going to go to jail. But you don't want another pending case when you have another case that's in the court. At least that's the way I would think. So maybe he didn't do anything to Varya at all. So maybe he didn't do anything to her. But we know he was threatening Shelby. He was threatening other women. He made mommy... He made mommy says bad words upset. So I'm just like, this stuff is crazy. He has this intimidation factor going on, like he's going to do something, which I'm told that he's a very abusive person. And I believe that. And not just to the women in his life, but to his kids as well. Hi, Ethel. Oh, the people sitting behind him are wearing purple. Okay. She doesn't need him for anything, so I don't know why she's still with him. Maybe she does love that piece of trash. I don't know. I really don't know. This is crazy. I'm sorry, I got to answer. Yeah, I'm just surprised that he is I don't see no remorse. I was hoping he would make a statement. Maybe he will. Knowing him, he'll be narcissistic and keep saying it's a ploy to set him up. But I was hoping he would take some accountability for what he's done. Yep. I don't think he did anything to her, but she has to realize now, if she hadn't already, that he was seeing Kirsten the same time he was talking to her. She has to see that. Then he came back and started dating Mary. Well, hopefully she realized the bullet she dodged now. Who knows about Varya's getting the house of some kind. I know she's selling 2 of his houses in Florida to pay that attorney. That I do know. That was in an email that was sent to me, that she's in charge of his stuff. She and his dad, but she was selling 2 of the houses he owned in Florida to pay the attorney. Now, the other lady that's coming up to testify, I don't know if that's the ex-girlfriend or the other ex-wife. I'm not sure. Yep, from day one on the show. It was just something about him. His eyes are so cold and beady. I want to know who's that little boy in the courtroom, because I don't think that would be his son. That kid doesn't look no more than 14. I don't know why you would bring your son to court to hear this stuff about your father. I mean, about his father, especially at that young age. Oh, he's supposed to take the stand. Ooh. He needs to take accountability for what he's done. Well, I know what I go through. I remember that. Yep, and that's what he was doing, because he went out of his way to make people think Shelby was crazy. He went so far as to file a police report in a district that she didn't even live in, and she was calling, and then she found it. It was in another place. Geoffrey is a sicko. He's a psycho. Yeah, I think him and Geoffrey could be related. Who knows? Because they both sound like narcissistic ass people. Yeah, but she won that visa lottery. So she doesn't need Geoffrey to stay here. She can get her citizenship on her own. She doesn't need Geoffrey. Well, one of his sons is already married. Ms. Moon is the first wife. I think she's the first wife. Wait a minute. Is she the first wife? I think she might be the first one. Or is she the second wife? Shit, I forgot. Yeah, but that's not going to help him. She said something about his other wife. She didn't say about a current wife. Now, if she said current, my ears missed that. Oh, his son's supposed to oh my God. He was a police officer? Oh my God. I was just watching this thing on Drew Scott, Scott Drew, or what was it, that killed both of his wives, and he was a cop too. I was just watching that. I'm sorry. She's the second wife. Okay. He's been married twice. Hold on a second. Hold on. I'm going to tell you. I can't remember. Was it 3 times? Hold on. Let me ask Google. How many times was Geoffrey Paschel married?
Here's a summary from
4
Showbiz
times.
Cheat Sheet.
4 times. 4 times. How many times was Geoffrey Paschel married? 4.
According to Showbiz Cheat Sheet, it's also been confirmed that Geoffrey has been married
4 times. He's been married 4 times. It cost him his life. Oh, Angel, you got to tell me about that. What the hell? He has 12 kids. Well, he claims he has 12 kids. Yeah, she was living at his house. I don't know if that's the ex-wife or the ex-girlfriend who have the kids in Canada, but he's been married 4 times. Yes, Drew Peterson. Thank you. Probably the judge had to go to the bathroom. They might be married. They might be married, and they're just keeping it hush. But I looked in the Tennessee records, and I don't see a thing for marriage. So maybe they did get married in Vegas. Never thought to look in Vegas. Yep, Drew Peterson. I just watched that again.
Yes. Yeah, I think I can do that. Okay. Well,
Thank you, Mother Teresa. Oh, I did see John did go live. Okay. Who we calling now? They mentioned a current wife, so maybe the current wife is Varia. But they swore they weren't married. That's funny. Just like Gino slept with over 100 women. Okay. Mother Teresa just sent me something. What is it? Okay. Thank you, ma'am. Maybe they married in Florida. Never looked in Florida. But I know she was down there with his mother for a while. Nope, they didn't like him at all. I wonder what her mother has to say. Thank you, Ashley, for becoming a member. I love your profile pic. Thank you. Let me grab my salad, guys. It's already made. It's just in the refrigerator. Hold on. Okay. Got it. Okay, what time? 11:08. I have a 12:45 meeting. Oh, God. Let's see. Whew.
With counsel, state's attorney is here with us. I was informed by my court officer during the break that we were having an issue with one or more people in the gallery. I'm not exactly sure, having verbal, audible responses to some of the testimony that was
Ooh.
being provided.
Maybe
I
Mary?
want to make very clear that we have to maintain decorum and order within the courtroom. And part of that is that there can be absolutely no responses from the gallery, either verbal or nonverbal, as to any of the testimony that has been provided. I understand my court officer during the break provided the appropriate admonishment to that effect. And I also understand that Mr. Isaacs spoke to some of the people on his side of the aisle to that same effect. And I do appreciate you for doing that, Mr. Isaacs. General, you ready to proceed with your next witness? All right.
Remember the last time after the court, they were out there having, they actually attacked
At
Kirsten.
this point, we do have a video jail visit of the defendants that we would seek to introduce. As I guess we haven't introduced anything yet.
That's fine, Marcia. That
Yes,
is so
this being
fine.
2. Is there any objection?
None.
Okay. This will be received as number 2.
It's about a 15-minute long video of that the defendant has a jail visit with his mother, I believe. It's the relevant portion that I was wanting to play for the court begins at 7 minutes and 45 seconds.
Ooh, let's
Okay,
listen
would you
to
like
this.
Publish that at this time.
I'll go with that.
You said 7 minutes and how much?
45.
I'm going to talk to her and said that we can. What are you eating? If we go to your house to make sure everything's okay?
No, I just got it under control.
John,
For the record, I've started the video at 7 minutes and 30 seconds.
Josh and Ashley are there, but they need to leave, right?
If nobody can talk.
Yes, it's on court TV.
Maybe she can say like, think about the children, how they're affected or something like that,
Yes, I'll mute you. I'll mute you if we're still going.
Okay, I'll tell him. I think she was gonna do that anyway.
Yeah, she probably can make a difference though, not an unsolicited difference, not a call, not an email.
Okay, John, just go there and talk to her.
With the children or something.
With the children, okay. I'll tell her. I'll call her now.
Yeah, maybe my else can talk. Say how devastated he is or whatever.
She could have to, she would do that now, right?
When she could talk, the sentencing and say, I don't, I think you, whatever, learning lessons.
Well, to do that now, you want to wait a bit.
That's up to her.
Okay, I'll tell her. Kristen has a plan, so I'll talk to her and tell her you need great visit. I sent it the phone number, but I don't think it's probably the same number, is it?
It's not, no.
No, I think it's not.
You know where his phone number?
Huh?
You know where his phone number?
No, I have Tracy's phone number. No, I don't think I do. I mean, I might.
It's great.
416 something, I'll look. 416 something, okay. 6, okay.
I thought it was Mary.
703, I'll look and see if I have it. I don't think I got very many of those phone numbers, so. Do you think you want her to contact her too?
No.
I know. Oh my God.
He talking to her.
Okay.
So he has family.
Okay. I know. Oh my God.
But we're going to need to call that girl. She would need to make a visit.
I'll visit that girl, okay.
It's a court TV app.
Unsolicited, okay, I'll tell her.
Is her house or is it school?
Okay. Does she know where the house is? So you did too, right? That's Miss Dakota.
Yeah, so people buy.
Say it again?
1525,
1525,
1425,
okay.
Aldenwood,
What was that?
as the word. A-L-D-N, Wilson.
Okay, got it. Is that right?
Yeah, that's right.
Okay, 1425.
Yeah, for the record, I'm stopping the video at 10 minutes and 41 seconds. General, I'm assuming the date on this it was recorded on January the 28th of this year.
It was not, Judge. This was actually October the 17th.
Okay. All right.
So,
Any further proof, General?
yeah, Judge. The next thing I would ask is I've got certified copies of convictions from Blount County, as well as certified copies of convictions from the district court in the Eastern District of Texas. So I would ask those to be the next exhibits. The Texas ones are two separate ones. Do we want to make those separate or?
Sure. Let's mark them all separately. Any objection to those, Mr. Isaacs?
The only, obviously I will take the state's representation that they are certified. Pursuant to TCA 4035-106A1B5, there needs to be a finding beyond a reasonable doubt that the out-of-state conviction, if it's used to determine a sentencing range, must be compared to Tennessee law as it existed at the time. I understand from talking to Ms. Good, she is going to establish that prong, but that would be our only objection as to the foundation on the federal.
And I thought his mother lived in Florida.
Okay, sure. So it sounds like there's no
So maybe
objection
she
as to
came up for a
admissibility,
visit.
but you guys may argue over the effect of the.
Well, it's not admissible unless she can show what the sentencing range is that existed at the time beyond a reasonable doubt. And Tennessee law pursuant to State versus Brooks.
Well,
Well, I guess it's admissible.
It'd be admissible,
We could argue
sure.
it can be used to
Right.
taking the range too.
if for no other reason, it would be admissible as prior criminal conduct.
Yeah.
We can argue as to the import that it has on what range he's sentenced at today, for sure.
So, in response to the court's question, we don't object to admissibility. We would like to be heard on the issue of whether it should be considered an enhancing factor for range 2.
Of course. Yes, sir.
Next thing would be the pre-sentence investigation report and the addendum to the.
It probably is.
Report. Do we want those as a collective or?
Any objection to those?
None.
Collective's fine. I think they're really the same document.
Let's see here. Judge, I would also like to enter a copy of the Ms. Wilson's medical records.
So does that mean we're not going to have any more witnesses?
Custodian of records. At this time.
We would make the same objection regarding the medical records that we did at trial under the 90-day notice provision, and we've still not received memorandum any of the statutory prerequisites to have medical records admitted.
Judge, I'm not sure what this 90-day issue, I'm not sure that the rule actually calls for 90 days.
So we're talking about authentication through the affidavit of the custodian of records.
Yeah.
And I know there's a notice provision. I don't know. Well, for one, has there been notice provided that you intended to introduce these through an affidavit?
So I provided them with these records almost 2 years ago. At trial, the court did exclude the medical records because I had not filed written notice. However, and if the court would like to see the case, now I can't remember it, of course, because we're talking about it, there actually is case law stating that if the records are provided to defense counsel in discovery, then that in and of itself puts them on notice that the evidence could be, sought to be introduced.
Correct.
Written notice actually is not required by the rule.
Can we see that
We
case?
try, give me a moment, I'm happy to go find it. But again, they are on notice that we could seek to introduce these.
Could be, Christine, could be, because he was giving out Brittany's address.
We notice in the operative term to seek to introduce, so we would renew our same objection we made at trial.
Public hangings.
And I apologize, Judge, I misspoke. It does say that written notice is required. However, the case that I'm specifically referring to, and I'd be happy to go and pull it if need be, states that once the state actually puts it, it gives it to defense counsel and puts it in their discovery response or something like that, it then puts them on notice that it could be sought to be introduced.
Okay, well, I'm in a position where I don't have that case in front of me. All I have is the rule, and
The rule is pretty clear that a party intending to offer a record into evidence under this paragraph, referring to business records, basically, must provide written notice of that intention to all adverse parties and must make. the
But she
record
gave it to
declaration
them.
available for inspection sufficiently in advance of their offer.
We don't need the records. We see your face.
Into evidence to provide an adverse party with a fair opportunity to challenge them. So I'm kind of at, here's what the rule's telling me. I don't have any authority
Hi,
telling me
KG.
otherwise that I'm aware of. So I will sustain the objection at
Okay.
this point. That'll be the court's ruling.
That's fine.
All right. Any other proof, General?
And Judge, I don't know, I do have a copy of the statute as it existed in 2000 related to drug offenses in Tennessee that Mr. Isaacs was referencing.
Yep.
I don't know if we want to introduce that as an exhibit or just
Cross
retire.
that for the record, I'm fine.
Okay.
On federal conviction.
Yeah, I couldn't hear what the
Federal
mother was
statute
saying
or
either.
Tennessee
This is the
Only
Tennessee
Geoffrey.
statute.
Is-
So and I guess we can talk about this a little bit. So the conviction, the federal conviction is for possession of cocaine with the intent to resell. Well, he's got an attempted, and there's two. And so I've got the Tennessee statute as it existed in 2000 at the time of the.
I'm not
convictions
defending him.
related
He is
to
a
the
piece of
possession with
garbage.
the intent to sell
I see.
controlled
Okay.
substances.
All right. Thank you.
So,
Yeah, Mr. Isaacs, do you mind if I take a copy of that?
Yeah.
Okay, thank you.
I think that is all of the. It's time, just ask for argument.
Okay, the state is rested as proof at sentencing. Will there be any proof in defense?
Your Honor, we have a number of arguments to make regarding our sentencing memorandum, but we have no proof at this time.
Okay, very well. Let's move on to argument. And I guess if both parties could begin.
Can we
with
get
their
to the sentencing,
arguments as
please?
to the appropriate range of sentencing.
It's contention that Mr. Paschel is a range 2 multiple offender based on
Yep.
numerous convictions that are now entered into the record. The first of which being a conviction, actually 2 convictions out of Blount County, but the state does concede that for
Oh,
purposes
okay, Glenn.
of enhancing the range, because the date of offenses were the same, I think that they would actually only count as 1 conviction. But those were for B felony, the sale of, I believe, if I may draw that.
B felony. He had 1-2 felony. Let me see. What's the other ones?
Blount County convictions were 2 B felony convictions in 1999. One of which being the possession of Schedule 6. I'm sorry, that was a misdemeanor conviction. I apologize. He had possession of Schedule 2 with intent to resell, Class B felony,
Possession of Schedule
and
6,
possession of
controlled
Schedule
substance.
1.
Yep.
Class B
Possession.
felony.
Yep.
So those were in cases out of Texas. The first one was possession with intent to distribute cocaine and marijuana. And the second one was attempted possession with intent to distribute cocaine. And so for purposes of the statute as it existed in 2000 when he was convicted. The statute states that, again, the issue that we ran into here was the judgments in the federal cases don't actually list a specific drug quantity. And so we have been going round and round with the district court in Texas. The only way that we could get something that specifically stated the drug quantity was in their version of a PSI, which is sealed. And I even had an AUSA out there attempt to file a motion to get it unsealed. That was not fruitful. So while the state cannot say a specific quantity as it relates to these convictions, when we look at the statute as it existed in 2000, and it's really the same language even today, basically. At a minimum, the sale of any amount of Schedule II cocaine would qualify as a Class C felony. And so the state contends that we have the Class B felonies in Blount County, as well as the federal convictions that at a minimum would qualify as a Class C felony under Tennessee law. And so we would ask the court to find that he is in fact a range 2 multiple offender based on
Yes.
May it please the court, this is a quintessential example of why Tennessee courts and statutory law require a finding beyond a reasonable doubt. TCA 4035-106A1B5 provides when classifying prior out-of-state convictions to determine sentencing range, elements of out-of-state offensives must be compared to Tennessee law as it existed at the time of the prior conviction.
He's easy on the eyes. He really is.
Not as the law currently exists. Citing in the commentary, State versus Brooks, 968 Southwest 2nd, 312, 1997. What the issue is before the court, one, in drawing on our experience, and I would ask the court to draw judicial knowledge in terms of being a federal practitioner and dealing with the pre-sentence reports, they do not contain the elements of the crime. The judgment for federal judgments, as you can see here, are very formalistic and do not contain the elements of the crime. One thing that's very important when you look at the issue of separate sovereigns, you have the federal forum, you have the state forum. At the heart of the charges is quantities. Federal drug cases begin in and are driven by drug quantities. That's why the state sought an AUSA who tried to unseal some of the information. That AUSA reached out to my office. I did not agree to unseal the pre-sentence report. So we would respectfully submit that without information regarding the elements of the federal offense,
oh my God,
compared to the elements of the
hey now, get the gavel
offense, as it existed at the time, it would not be an appropriate enhancement factor under 4035-106A1B5 and also under State v. Brooks. But quantities are very important. Quantities under federal law have changed regarding.
They've changed, but not then.
Administrations, whatever. Tennessee law is driven by minimums and whatever. So the fact that the state tried to get the information and was not successful shows that they know they need more. And
Amanda,
if it's range 1, that's still a very significant range for what Mr. Paschel is.
Yeah, he's done with him.
But we would respectfully submit that unless the state complies with the letter, not the spirit, the letter of this. And that's why when we have issues with federal cases and state cases, in terms
I want to know how many cases this man has tried. I'm finished with that
process. And if at the last minute you say, hey, I need this unsealed by a federal court, that's not the way it works. I mean, there would probably have had to have been an appearance from someone here or someone appearing pro hoc vici on behalf of the Knox County Attorney General's office in that federal forum, seeking to unseal the records and getting those certified. But that state has not met the requirement as articulated in State versus Brooks. We think that should not be considered as a applicable enhancement factor, and that Mr. Paschel.
Okay, I want the judge to tell him, okay, we've heard enough. Can we just get on with it? Yep, the laws at the time of the crime. That's what should apply, not what the laws are now.
I guess also the Blount County judgments as well. Thank you.
I'm going to leave it up. I'm supposed to be going live later on tonight with Debbie, and I don't know, because I didn't think it was going to take this long, and I have a lot of stuff to get done before I go on vacation, so I have to see. All right, Glenn Crack, you're going to be fighting in here with Lily and a lot of yeah, can he just shut the fuck up right now? We're sick of hearing you. He's guilty. We found him guilty. Now let me just sentence his ass to 29 years. I know it's not 29. I wish he can get life. But if he have extenuating circumstances, maybe he'll get more. The minimum is 12. The max is 20. So let's see what he gets. With no parole. She did that the last time after the trial. She and Jeffrey's friend actually started cursing out Kristen when they walked out the courtroom. So she should have known better. We're going to have to get you guys a judge to come in here that looks like that.
This is a somewhat different issue, but I do want to ask, I'll ask Mr. Isaacs first, and then I'll ask General Good. I'm not seeing anywhere in here where it says the date of the offense. Have you found that in here, or do you know that it's, I'm talking about the federal judgments. I know that's listed in the state.
No, Maggie.
Or the criminal complaint in federal court.
I see. Okay, very well.
I do pass those documents.
Well, I'm not sure. I'm not necessarily sure that it is.
Come on, can we just sentence him now? I got work to
When
do.
you say you have the documents, you mean the complaint?
I have the indictment.
Well, it's certified.
I pulled them off Pacer. No, those probably are not, but.
They're inadmissible. Okay, I just had that question. The state does carry the burden of proof beyond a reasonable doubt as the sentencing range, so I will give you the last word on this particular argument if you want it.
And Judge, I would just note, as far as.
Yeah, they are awesome.
I kind of thought that these might relate to the Blount County cases as well initially.
If you will look on the Blount County, the date of offense there, I believe, is 1997. We do have the date that the offense concluded on the front of the federal judgment. The federal judgment has an offense date conclusion of 2000, if that clarifies it all.
Oh, I see that on the face of it. Yes.
Yes. So.
I don't know how I missed that.
No.
It does answer my question.
No worries.
Any further argument as to this issue, General?
Nope.
No, Your Honor. The last thing we would say is just that we do not believe that a specific quantity is necessary. I did try and get that just for, to see if we could make it a little bit easier. But nonetheless, like the statute plainly says in 2000 and even today, the possession with the intent to resell cocaine in any amount is at a minimum a Class C felony. And so we would
You
ask
did your
the court
homework,
to
girl. I'm proud of you today.
find that he is arranged to.
And you're saying that the attempt would be a D,
I think the attempt would be a D.
which
Yes.
could go up 2 classifications to catch the B, aggravated kidnapping.
Yes.
Okay. I gave her the last word, Mr. Isaacs, but it looks like you have some.
You did, and I tried to sneak up.
This is an important issue, so if you have argument on that, I'll allow it.
And I think the court, for your careful consideration, but just simply, that's not enough to make the determination. What we have before us here in a federal case, and that's why they tried to unseal it, and the federal judge said no. And again, the standard's beyond
You just made yourself look
That's why we
stupid. They tried
certify
to
things
seal it,
here.
and the
Tennessee,
federal
it's kinda
judge said no.
archaic, kind of like the old wax stamp and whatever. But there's not enough to make the required finding when you compare the elements and the ranges, because we're guessing at things as we're talking. And I don't mean guessing in a deprecating way to the court.
Yeah, I understand.
But again, range 1 is significant, but this would just add another potential issue for appeal. If the AUSA would have unsealed everything, I would be sitting right there politely listening. But we don't have the appropriate records before us, and we would ask that it be range 1.
Thank
A
you.
Class C felony in
anything
Tennessee, you get up to 15
Okay.
years and a
This
$20,000
is
fine,
something.
$10,000 fine.
Usually, when I have a sentencing, I rule upon the range along with everything else, and it's generally not in dispute. It is in dispute here, and there's a very big distinction depending upon which way the court rules. I think it is important for the parties to know my ruling on that issue before they argue the remaining things that we need to discuss today, the application enhancement mitigation factors and anything else along those lines. So I hate to take a recess to do this, but I think this is an important question. I do want to go back in chambers and look at this a little bit before I make my ruling. I appreciate everyone's patience. I know you've hung with us all day here today, but this is an important question that we need to resolve in the correct way. So I'll be briefly taking the issue under advisement. Court's in recess.
Okay, so Class C felony in Tennessee, I just had to go look it up to make sure. Those convicted of a Class C felony may face prison time of 3 to 15 years and fines of up to $10,000. Tennessee aggravated assault is considered a Class C felony. So how long are we taking? Okay. You guys talk amongst yourselves for a minute. I need to take this call, and I'm muting this time. Okay, I'm back. As soon as she calls me back, I'm gonna have to grab that call. Okay, let's see. See, no, so what they're doing is they're showing his past. So they're looking, so now they're in the sentencing phase, so they can actually show his previous convictions and offenses. That's why the ex-wife was allowed to come up and testify. I thought the other lady was coming too, but I guess she's not. So then when the judge is considering his sentence based on everything, and if he feels that there's extenuant circumstances, he can add more time. But the minimum he can get is 12. And if they can't go any less than that. And if he does, I'm going to be shocked, because that is according to the state. And I was told earlier that the prosecution was looking for 16 years. The judge is hot. Hot. She had on a mauve or pink mask or something. I don't know why Mary wants to go after people in court. She should know better. I just don't get it. Priority requests. Forward. So I don't get that. Okay. Got it. So yeah, I really don't get why she's going after, and it had to be Kirsten again, or it could have been Moon, because I know she didn't really like her. Okay, let's see. Heidi, there are women that are like that. Sad but true. My sisters were with a guy like that. Oh goodness, what's going on? I haven't been able to listen. We just heard victim impact statements. We heard from Geoffrey's second wife, Miss Moon, and then we just heard what they wanted. They're trying to get him for Class C. So they're looking for a longer sentence for him, and they brought up all of his previous charges, including the drug trafficking charges, possession and trafficking. He needs to be found. He's already been found guilty. He's already been found guilty. Now this is just the sentencing phase. So he's already been found guilty. Does Tennessee have the 3-strike thing? I know we just got it where it's in California. I know we had it in Louisiana. I know it was in Texas now. I don't know if Tennessee has the 3-strike rule. Of course he's planning to appeal. Okay, so what is he going to appeal? The fact that he slammed this woman and beat her mercilessly? Is that what he's going to appeal? I was chewing. What are you appealing, Geoffrey? What are you appealing? She did not do this to herself. What are you appealing? Help me understand that. What is he appealing? What? Now, the defense said that they're not going to call anybody. He says, not today. So I hope we're not going to drag this damn sentencing out. Yeah, Mary's got some spunk. See, Beverly, you remember, I never liked him. It was just something about him I didn't like. I never looked into his history. I never followed him. When I would see him on Dom's lives, I would go in, and when Geoffrey would be in the chat, all these women in there fawning over him. Then he goes up on IG, he gets on the panel with them, and I would leave. It's just something about him I did not like at all. Yeah, she's in purple or pink with the jacket and then the mask. Yes. Yeah, the judge is a hottie. Yeah, he screwed up this time. A big gavel. Okay. Whoo! I just want him I didn't want him to lay the gavel down. I just want him to hit Geoffrey where it's going to hurt, in his pockets, because he's been moving money and hiding shit. So in case she goes after a civil suit, which she probably, well, I don't know. If I would, after he's convicted, I would go for a civil suit. This is why I never called the last time I needed an ambulance. So cops were involved and are to this day. Okay. Becky, are you moving now? I mean, are you trying to get out of there now and find another place? Or are you just hoping that he won't come around again? Okay, so they do have the 3-strike laws. Thank you, Addie. I was wondering if they had the 3-strike laws. Well, if you're in jail, I don't consider you having any good behavior. You're only behaving good because you have to be, because you're under lock and key. So, no. No, she's pregnant with her husband's child. Kirsten is pregnant with her husband's child. She got married 3 months after she was assaulted by Geoffrey. Let's give him, yes. Let's give him some time, baby. No, you didn't miss much. The judge took a break to go look at something. He should be right back. What he's really going to do is look at the comments and see how many people are thinking he's hot, all these different chats. And then he's going to brush his hair back again, spray some more cologne on, so in case he walks by, you can smell it. Oh, see, that wasn't him though. Ooh, sit down. Please get your head out my screen. Move. Oh my God, you guys have been great. See, nobody liked him. Oh my God. I believe he's got a microscope. I believe he has a microscopic penis. And yeah, I call that little man syndrome. Short everywhere, all the way around. Oh, you want me to share the people in court TV? I didn't want to share their chat because that's their private. Well, that's considered a private chat, and I didn't want to share their chat. The max is 20. Yeah, there's something about him. You can see he's always was something. Yeah, there was always something about him I didn't like. And believe it or not, I never liked Chris Brown. Never, ever, ever liked that little boy. Never did. Never liked him. Never liked him. And my mother told me when I was little, I never liked Bill Cosby. I said, well, how did I watch the Cosby Show? I thought it was funny. She said, you never liked him, even when you were little. I never liked him. But I always did like Sidney Poitier. Never liked Bill Cosby. Eddie, what do you mean you're in the wrong place? You're supposed to be in your chat? Because I know you have like 3 of them going on right now. Oh my God, Becky. So this makes your 3rd time moving or your 4th time. This is the lady that I was telling you about that somebody in the chat is from Canada. And she helped her to get in contact with these people. I think it's Smile Bright. I can't think of the name. Her husband actually kicked her in her mouth with his steel toe boots and knocked all her teeth out of her mouth. I'm glad you're not there by yourself because I know your son was there with you for a while. Addie, girl, what are you doing today? Yeah, there's no damn early release or no good behavior. You serve all your damn time. You did the crime, now do the time. That's what I liked about Beretta. Geoffrey is 41. Or has he had a birthday? No, he's still 41. I don't think he's had a birthday yet. So if he does 20, he'll be out when he's 61. So the thing is, even when you're in prison, I don't see where they have any of these programs to help you rehabilitate yourself. Now, they do have them, but they're not mandatory for them to take them or for anybody to actually enroll. Unless you're forced to by the courts. But I don't see them actually taking advantage of any of this stuff. Yeah, well, from what I understand, the guy that she's married to was an ex-boyfriend that she had dated previously before Geoffrey. So I guess he was her go-to. He makes her feel safe, and she married him. And I don't think people were going, oh, well, she must have been cheating. If she was cheating, so what? He was cheating too. He was cheating with Varya, getting ready to go to Russia to be on this show. I bet she didn't know anything about that until she saw him on TV. Yep, he thinks he hasn't done anything wrong. It's a big plot to take his child away from him so he can lose custody, and everybody is plotting against him and all his other shit. But yet you went home and you terrorized your household. So I don't feel no sympathy or empathy for Geoffrey. I can't stand him. And Varya is a dumbass. And I know Mary is a friend, but God damn, you see what this man has done. Come on now. Let's be serious here. Oh, you thought Varya was having a baby? Oh, Lord. Oh, Lord. Okay. Maureen. Now, that's funny. They don't pay your lawyer. You can't make this man an ass. He is a legit asshole. Hi, Shirley, how are you? Oh. Went through DV for 38 years in Florida, and I got him off. It's the classic batter. Oh, my God. How did you get him off? Yeah, he's got a Miller. Yeah, he might have a nano. I don't even think he has a millimeter. Yep, when he yelled at her friends, I was like, what kind of asshole is this? And her mother, and somebody said it in the chat, her mother or her brother did not like him at all. I don't know why I thought that was her cousin, but that was her brother. We have some cops getting ready to go to court over DV. One is looking, 130 years. That's in Canada. Yes, he does. It reminds me of a creepy uncle, a dirty, you know how you always have that dirty old uncle and they always tell you, no, don't go around him. No, you still. Yeah, I'm trying to think that I ever have one of those. But yeah, that's who he reminds me of. Oh. You guys are soft on. Well, Becky's in Canada and somebody's getting ready to, one of these cops for domestic violence is looking at 130 years. You can't be that soft. I got to look at Canada. I'm going to have to look at Canadian laws then. No, and he was offered a plea deal, according to him, with no jail time. He would just have to admit what he did. And he said no, because he had everything to exonerate himself. Well, it doesn't look like you have it now, do you, Geoffrey? Yep, that's what I was. See, everything I've seen, they said that they weren't married. But then again, they could be lying. Who knows? Yep, he thought he could beat the system, so he's getting exactly what he deserved. They offered him a plea deal, according to Geoffrey. He had to admit what he had done, and he would have no jail time. That's what he said. And I don't know why they would admit what you have done, and you don't have to do community service or probation or anything. But he wouldn't have had any jail time, and that's according to what he stated in an interview he did. And I don't know if you remember when they were asking him about him giving out interviews and him being on different YouTube channels, and he tried to act dumb. And I was waiting for her to pull it all out. I really was. Mary is live on IG now. Ooh, let me see what Mary is saying on IG. She might be mad at me, but I don't care. Let me see. Mary is live on IG. Let's see. Mary, blue. What account is she live on? Oh, I see her and Morphin. Ugh. Yeah. I don't see Mary live on IG. Whose account is she live on? Because I'm on her account. They have the 25.9K. Oh, the news. Yeah, they're engaged. Okay, talk amongst yourselves. I got to take this.
We're in Paris, Kentucky, where 30-year-old Bass Webb has been charged with 2 counts of attempted murder. This surveillance video taken outside a Kentucky jail a week earlier captured the moment when Webb, a former inmate there who served 3 months on assault charges, accelerated his car and tried to run over 2
I'm a millionaire? I'm not a millionaire.
Crypto is complicated. You can hand your taxes off to me.
Okay, guys, I'm back. So I don't know what's going on with Court TV. I think they are, what is that? I think they're recessed for the day because it says streamed 11 minutes ago, and it doesn't look like they're going to put up another live stream. But no, I had to take that. I had to take that call. It came in from my director. So yeah, so I don't know if he's come. I don't know if they're coming back today or not. I don't know. So what did you guys think so far, but what's going on with the trial? So I can project this. Let me see. I can share it again, but it doesn't look like they're coming back. See, because, okay, because here's what I'm looking at. It says it was streamed 14 minutes ago. So that's what it's showing me. That it was streamed 14 minutes ago. So I don't know if they're going to come back or not. He said he was taking a recess, but he didn't say a lunch break. Ooh. So I don't know what to do here, guys. What do you think I ought to do? Because I know that we're going to get a verdict. I mean, not a verdict, that he's going to get his sentence today, but it depends on what the judge, let me see, what does he say? Yeah, it says it was 5 hours and 55 minutes. It was streamed 14 minutes ago. So that means that they would have to start a new stream. So I'm going to keep my eye out on it. And when I see, so when I see that they're going to bring the verdict in, I'm not laughing. I haven't combed my hair or anything today. I'm working from home. So this is me. Look, this is me. I'm working from home. So when I see that they're going to do the sentence, I guess I'll have to do, because the judge is taking something under advisement and he's looking up case files. And Geoffrey, I enjoyed your input. Thank you so much. We don't have the verdict. Well, the verdict is guilty. We don't have the sentence yet. Today is sentencing. Read my messages after. I will, Becky. I will read you. I just saw that you sent me some messages. Also, my other court reporter told me that Mary was asked to leave the courtroom. Okay. Mary was kicked out of the courtroom. Don't know what Mary is thinking about going after a witness. She should have learned from the last time, but she was kicked out of the courthouse because she blessed Geoffrey. Oh, she blew Geoffrey a kiss. She blew Geoffrey a kiss. So Mary was kicked out the courtroom. Oh my God. But the judge said that there was some disruption in the courtroom, but she blew Geoffrey a kiss. Okay. Isn't Varya in there? Why isn't Varya blowing him kisses? She's staring at him like she's crazy. Thank you, Sarah. This is called not even brushing out my hair this morning, which I have a meeting. I just finished that meeting. It was a pre-meeting to my meeting that I have at 1. So it was a prequel to the meeting I have at 1. That's just for us to touch bases, me and my director, before we go in with the big wigs. Oh my God, you guys are too much. Thank you, Geoffrey. I'm serious. This is my first time seeing you in here, maybe. I don't remember, unless you were coming in under a different name. But the mayonnaise jar, if you have Blue Plate, I'll be happy. I love Blue Plate mayonnaise. It's straight out of Louisiana. And I ordered that through Amazon as well. Yep, she was kicked out for blowing kisses. Really? For real, Mary? Oh, so it's back on now? Wait a minute. Hold on. Let me see. Can I get... Oh, I don't know if I can just stream Court TV. Hold on. Court TV, Court TV. Hold on. Court TV, Court TV. Hold on, hold on, hold on. Okay, let me see. Stream live now. I don't see Geoffrey. Hold on. Hold on, I gotta let the commercial go. Hold on, hold on. Oh, let me let that commercial go by. Hold on. Okay, I don't see, I know what you're saying, but I'm actually on the Court TV website itself, and I'm not seeing it. It's not the YouTube version. And you're saying it's on right now. Why am I not seeing this? Hold on. Let me go to Twitter and see if it's going to pull up there for me. I'm not seeing his thing. Because I need a link in order for me to go to do a live. I can't pull it directly from Court TV. That's a no-no. I need the link that they give you to stream live. So the judge is back in court. How come we don't? Hold on. Let me go back to Court TV again. Let me go to the link. Let me go to Court TV, the YouTube version. And with the link, Court TV. Okay. Nope. The link that I normally use, they're not streaming live at all. Watch Court TV live. Okay. Hold on, guys. I'm trying to see why. Oh, I have it. I have it. I have it.
Under Tennessee law. And because you're dealing with cocaine in either of these instances, I think that Section 841A is analogous to Tennessee law. The elements are the same, that if these offenses were committed in the state of Tennessee at the time that they were committed by Mr. Paschel, they would be classified at the very least as Class C or Class D felonies, potentially B and C felonies if the amount of the cocaine was 0.5 gram or greater. Under the progeny of Apprendi, it is appropriate for the court to consider certified copies of judgments of conviction such as this in order to establish range or to enhance sentences. And based upon that, I do find at this time the state is proven beyond a reasonable doubt that Mr. Paschel has 3 convictions.
I was talking my butt off and I wasn't
that can
even
be
on the
counted on
thing.
different offense dates. 2, of course, being the number that he would need to reach range 2 on a Class B felony. And for that reason, I do believe that the state has shown beyond a reasonable doubt that Mr. Paschel is a range 2 multiple offender as to the aggravated kidnapping offense,
Yes.
making his range of punishment being somewhere within the range of 12 to 20 years. So with that, I would like to hear argument from the parties regarding the appropriate sentence within that range. General.
Thank you, Judge. I know the court has read the sentencing memorandums in this case, so I won't belabor it, but I did just want to touch on the enhancement factors that we noted in our memorandum. The state in this case, at a very minimum, is asking for a mid-range sentence of 16 years. We do believe that is appropriate given the number of enhancement factors that are cited within the memorandum. The first of which being that he has a previous history of criminal convictions and behavior. Again, we heard about the criminal behavior from the witness stand here today. That is completely separate and apart from this incident. We heard about years of domestic violence towards Miss Moon. We heard about multiple instances of prior violence against the victim in this case. And so we would ask the court to find that that enhancement factor does apply. He also does have a number of misdemeanor convictions, as noted in the pre-sentence investigation report that I did not include in my sentencing memorandum. He has a theft conviction from 2014, a theft conviction from 2013.
Look at it.
Believe within those certified judgments from Blount County, there's also maybe a simple possession of a Schedule 6.
Oh, he hates that
as
prosecutor.
well.
Look at the way he looked at her.
And so he also,
I love the law, and I love the way this judge went through all of the details in his analysis.
I do too. Can you get off my screen, please, so we can get the
convictions
sentence?
Count in Tennessee as prior convictions. Now he's hearing arguments from both sides as to what sentence they recommend, 12 to 20 years. We're going to take a break. We'll go back to court when we come back.
Damn!
It's monstrous.
Okay, let me turn that down.
We shall have to see where the evidence leads
Everybody taking a damn break.
us.
Oh, what did I do? Uh-oh. I did something wrong. What did I do? Oh. What did I do? Guys, I don't know what I did now. I just clicked it. Let me go back into it. I don't know what I did, but I don't know if it's me or if it's just frozen.
Going to the strip club for the wings or for the thighs? I order the sweet chili wings every single time we go up in there. What? This is
Okay.
Somebody else been getting your mama's jelly cookies. That shooting still on?
All right, hold on. Let me get you back in there. It was me. I clicked the wrong thing. Whew.
Newsy tonight is changing the conversation. Incredible footage coming in live right now. Away from opinions. Arguments.
Okay, so I'm going to turn the sound down so we can just wait until they get back in the courtroom. So we'll just make, so what do you think? So what are we looking at? So we're going to do 16. You think he's going to give him the whole 16? Or you think he's going to feel sorry for him? Or he might just give him the 12? I just want to know. What do you guys think? 12 to 16? Judge Hunky all day. $20, $16. You're hoping for the max. Yeah, that's the commercial. As soon as it goes back in, I'm going to raise the sound up. Oh, dismiss. I'm not going to that meeting. Dismiss. Okay. I got so many court TV links open. It's not even funny when I was trying to get this trial back. Oh, her eyes are gorgeous. Okay, are we back? Can we just get with the judge when he just giving out the sentence, please? That's all I want to know is when he's giving out the sentence. I need to run. Oh my goodness. I like this show. I do watch that. Eon Plus, and they're doing a good job on the Murdoch stuff. Oh, leave me alone for a minute. I said I'm away. I'm at lunch. Okay, Court TV, are they back? We'll be right back. We'll be right back. Are they back? Are they back? Are they back? Still commercials, still commercials, still commercials.
In Chicago, the former police.
Okay.
McDonald is scheduled to be released today.
What?
Jason Van Dyke was convicted of second-degree murder in 2019 and sentenced to nearly 7 years in prison. He has served only 3 years and 4 months. In Louisville, Kentucky, jury selection has been delayed in the trial of an ex-police officer involved in the raid that killed Breonna Taylor.
Oh,
Kentucky's
shit.
governor has declared a state of emergency ahead of an incoming ice storm. The trial is scheduled to resume next week. And in Tennessee, the sentencing hearing for the 90-day fiancé trial is underway. Geoffrey Paschel will find out how long he will be in jail for the beating of his ex-girlfriend that happened in 2019. The defendant maintains his innocence.
We know he's not
And that's where
innocent.
we want to start the Paschel hearing, the sentencing hearing, compelling testimony from 2 victims this morning. Let's catch you up. The court came
No,
back
we
and
already
bottom
did
line
this.
said, I've looked at his federal convictions. He stands to serve on these charges, this conviction against the ex-girlfriend for kidnapping and assault, 4 different charges, 12 to 20 years. He then said, state defense, do you want to make an argument as to how many years?
Yeah, I said
you
I'm at lunch.
recommend
I have
or
my
you think
team's
he
thing
should
saying
serve?
away, and
We're
they
starting
keep
with the
sending me
state's
stuff.
argument. You haven't missed any of it. Let's take you back to court now.
No.
Your Honor sat through the trial, heard the testimony of Ms. Wilson. Ms. Wilson testified at trial that testified at trial and today that she blacked out and was blacked out for probably half the time that this almost 2-hour assault was going on. She stated that she was in and out of consciousness. When they finally get up into the bedroom and she lays down, she's fighting to remain conscious so that she can try and then get out once he lays down. She talked about being in extreme physical pain. I mean, the pictures support that. She literally had, her forehead stuck out 2 inches. She had scrapes on just about every single part of her body. And in this case in particular, Judge, while I do concede that aggravated kidnapping does have the requirement of bodily injury, I believe that the proof in this case actually established serious bodily injury. And when we look at the statutory definition for serious bodily injury, it is the size of the injury on her extreme physical pain, protracted or obvious disfigurement. And I think in this case, the evidence was that all 3 of those things were present. Ms. Wilson testified. I mean, this was blacking out for an hour, in and out for, almost an hour probably. She testified that she was in extreme physical pain, which makes sense given the size of the injury on her forehead and on the rest of her body. She had obvious disfigurement. I mean, she walked around with that knot on her head and black and blue for almost a month, she said today. And so while we do concede that bodily injury is an element of aggravated kidnapping, I think it goes beyond that in this case. When we look at bodily injury, the definition is a scrape or a bruise or a cut, things like that. That's not what we had here. We had a woman who had a concussion, who was literally unconscious for half the time that this assault was occurring. And so we would ask the court to find that the injuries were particularly great.
Yep.
And that kind of goes along with the next enhancement factor, that during the commission of the felony, the defendant intentionally inflicted serious bodily injury to the victim. Again, we do believe that this does apply because serious bodily injury is not an element of aggravated kidnapping. It's only bodily injury. And we do believe that the evidence supports that she did suffer serious bodily injury today. So we would ask the court to apply those enhancement factors. Again, as to the length of the sentence, this is a sentence that has to be served at a 100% service rate. He may receive jail credits up to 15%. But given the history that we heard from that witness stand today, this is an individual who, for the last 15 years at least, has tormented the women in his life, has verbally assaulted them, has mentally abused them and controlled them.
Guys, I'm going to switch to the other court TV camera because it has a better view. Hold on. Let me just switch to that other one.
These women, we make a lot to do in these cases about the fact that the women stay, but
okay,
a very high lack of potential for rehabilitation.
I wanted that view.
As we saw from the witness stand, you know, he is still blaming this entire thing on her. And even after conviction, he's directing his family to take his kids to her house, giving them her address and saying, take my kids there, and ask her to testify, you know, for me at sentencing, to say that I've learned my lesson. He's taken absolutely no responsibility for this. And I understand, in the state, again, we understand that because he did plead not guilty. But we do not believe that he was truthful when he testified at the trial. And the jury also apparently did not believe that these injuries were sustained from falling into a door. And so we do believe that he has a very strong lack of potential for rehabilitation. And so, again, Judge, at a minimum, the state would be asking for a mid-range sentence of 16 years as a range 2.
Yes.
Mr. Isaacs?
We are going to take a break. You just heard the state argue a mid-range 16 years for this defendant, saying his high lack of potential for rehabilitation is one of those reasons. We'll go back to court when we come back.
I don't want you taking a break. Jesus Christ, woman. Can we just get on with this? Why are they making us suffer like this? I can't. Nobody understands what I'm going through right now. Another damn break. The judge isn't breaking. Maybe they're tired of hearing the attorney. Maybe they're tired of hearing his attorney. How many damn breaks do you need? Let me go pull up my damn court TV. And if I get a hit, I'm going to get a hit. Shit. Court TV. Is this one going on? Yep, it's still on break. I want regular court TV. Because I don't think regular court TV is taking all these damn breaks like they are. Court TV. And that's the one I just had on. Court TV, homepage. Okay. We know he's going to jail. They're not going to release him. We know that already. I just want to get this over with him. Nope, they are on break. They're on break. They're on break.
Free Movie Channel has something for everyone. With no subscription or rental fees, Free Movie...
Let me see, because they're on break. I don't get it. Yes, I went live. Yep, they're still on break. They haven't went back to the courtroom yet. I'm looking at both of them. I'm doing the stream one, and then I have regular court TV. So I guess they're really on break. So, yep.
Call or visit us online.
Oh, wait a minute. Are they going back?
90-day fiancé, you may be familiar with, Geoffrey Paschel, was convicted in October of 21. Right now, we're in the sentencing hearing. The court said 12 to 20 years are the sentencing guidelines. The state just argued we want mid-range. 16 years, Judge, is what we are asking him to serve. We're going to take you back into court. You've not missed any of the arguments because now the defense has the opportunity to make argument to the court.
May it please the court, we are before the court in a sentencing that is taking place after a jury trial. Wherein Mr. Paschel, at the beginning of this journey, entered a plea of not guilty. Mr. Paschel took the stand in his own defense and was able to articulate what he says happened on the night in question with his interaction with Ms. Wilson. So it's in that context that we come before the court in a sentencing hearing with two different versions of far apart, two far-reaching versions of what transpired on that night. The jury, after hearing the proof and the evidence, decided that Mr. Paschel had committed those offenses under Tennessee law. So as I stand before you today, it's atypical in terms of when we say that our client is remorseful, although he is, whether we're doing certain things to accept responsibility, because this was a trial where there was two very different differences of opinion. And having cross-examined the victim and Ms. Moon this morning / this afternoon, we don't wish any of those women that have testified or Mr. Paschel any ill will or disrespect, but there are very specific legal criteria that the court has to make judgments and findings based on the enhancement factors the state has filed. And I think the court has heard not only the testimony at trial, but the testimony of those individuals this morning. So we are asking the court to focus on the law as it applies to Geoffrey Paschel, the person, and the trial. Having said that, we have attached a number of letters of support for Mr. Paschel as it relates to the appropriate sentence the court can impose. There are 39 individuals that have spoken to the court via their letter, via their proffer regarding Geoffrey Paschel, the individual. They paint a far different picture from the testimony that the court has heard this morning. This is a cross-section or a cornucopia of people that have interacted with Geoffrey throughout his life in a variety of contexts. There are periodontal surgeons, there are teachers, there are family members, there are engineers, there are leaders in our community. There are people that have known him his entire life. And by and large, throughout those letters where people are attesting and offering their opinion regarding Mr. Paschel and his character, which is relevant under Tennessee law as it relates to his amenability for rehabilitation, whether it relates to specific and general deterrence. They paint a Geoffrey Paschel that is supportive, caring, and there. For example, Denise Compton, a registered nurse, indicated that she had known Geoffrey through the years and found him to be an honest, pleasant, kind, caring, loving person,
Can we
as
not
well as a
read our
very
39
nurturing
letters
father.
seriously?
He's a man
have
who
a
loves
very important
nature and all of
meeting at
God's
1 o'clock.
creatures. I have personal experience witnessing each of these qualities. And she lists a number of examples. She talks about him volunteering and helping with Vacation Bible School when he brought his sons. When his youngest son fell critically ill, Geoffrey stayed with him in the hospital day and night until the end. Our church family helped with the arrangements while totally devastated by...
I hate to do this, but none of this was evidence and was introduced in the sentencing. And so I don't believe it's appropriate for Mr. Isaacs to just get up here and kind of grandstand his client based on these letters. No character witnesses took the stand, and so I don't think it's appropriate.
We're offered one, there's not been an objection by the state.
It hasn't been offered until now.
Well, it's been filed.
Let me rule on their objection. There has been no testimony regarding any of the items that were appended to the sentencing memorandum filed by the defense. As we know, exhibits to a motion or a pleading are not evidence. They will be part of the technical record, but they are not evidence that can be considered by the court as part of the record. Now, having said that, they have been appended. They will be
right
in the
here.
technical record, so I'll let you argue your case.
Thank you, Your Honor.
Yes, sir.
Well, the defense got away with attaching exhibits talking about the good character of the defendant. And the court just said that'll be part of the record, and I will consider that when we come back. We'll go back into court for more argument by
Are
the
you
defense.
serious? Oh my God, come on. Seriously? I can't with these people. It just, yes, you're guilty. Here's your 16 years. Serve it. Don't give a shit. You deserve it. Come on. Sweetie, this is crazy. We don't need to argue. We've already found him guilty. Throw his ass in jail. All day long with this shit. Come on now. Another potty break. How come we weren't having all these breaks earlier today? Why? We weren't having all these breaks. And they're not putting commercials in here. So I don't get it with all the damn breaks. I really don't get it. I got to look in Pacer at something. Okay, let's see. He looks like he sells used cars. What? I thought you just took your dog out. Maybe he's putting everything in the evidence now. I hope he's not reading all 39 letters, because I don't need to hear all 39 letters about what a good person Geoffrey was or is, or what these 39 people think that he's probably beat up, abused, and loaned money to or paid to write. Yep. Oh my goodness. I'm gonna have to look at that in Pacer. I have to look at that. Oh my goodness. Yeah, OJ's it was quicker. At least the sentencing, well, there was no sentencing, so oh my God. Teresa, I hope your doctor said that it's okay for you to drive even though you've been driving. Yeah, he put them through hell. Nope. His sentence wasn't that long. Good God. Yes, I got it. I have it. We're going to have to ask the judge if he's on OnlyFans. I'm really going to have to put you guys, I was fixing to take him out and then you found out. I'm sorry, Geoffrey. I'm sorry. No, I just think that's them. They're trying to prolong this for viewers. I don't know what they're doing because they're not even showing
every letter from, again, a cross-section of leaders in this community, people that have been touched by Geoffrey. Michael Johnson, a legislative assistant to the Florida House of Representatives, talks about him being a genuinely kind human and witnessed the acts that he carried himself with on a daily basis toward his family, their children, neighbors, his work ethic, his family values. The list goes on. And again, it's interesting to me that the state has made this objection because we respectfully have not ever had that objection made by the Knox County Attorney General's office as it relates to letters. And we understand they're not being offered as substantive evidence, but evidence of general specific deterrence and inability to rehabilitation. But we would ask the court not only to take judicial knowledge, but to consider those as it relates to the appropriate sentence. In terms of the state's enhancing or aggravating factors, they have indicated that they are asking the court to enhance Mr. Paschel's sentence based on serious bodily injury. Serious bodily injury is defined by Tennessee law under TCA 3913-304 as a cut, bruise, burn, disfigurement, physical pain, or temporary illness or impairment, or the function of a bodily member, organ, or mental faculty. It's interesting. Serious bodily injury is defined as substantial risk of death, protracted unconsciousness, extreme physical pain, and it goes on. A broken bone of a child that is not applicable to Geoffrey Paschel, but those are elements. And the state had conceded in their argument that are applicable to especially aggravated kidnapping. They are not applicable to the offense for which he was charged and convicted, aggravated kidnapping. We did not receive notice. I mean, the state had made the choice to bring these charges, present those to the Knox County Attorney General grand jury. The Knox County Attorney General's office chose the method and manner they were presented to the grand jury. And if they were going to allege serious bodily injury, then it should have come out especially aggravated kidnapping. Then Mr. Paschel would have had the right, we would have had the ability to raise the issue of serious bodily injury for the jury that was impaneled. But now we are addressing it in sentencing.
You're kidding me.
We would respectfully submit that to ask the court to consider an offense greater than the offense which Mr. Paschel was charged with in determining his sentence, violates his constitutional right of due process. And we would also cite the court to State versus Goebel. A defendant has a constitutional right to the notice of charges against him. The U.S. Constitution, the Sixth Amendment, Article 1, Section 9. And while an indictment has to prove adequate notice of what he is charged with, it also precludes the state from going in after conviction and seeking to enhance.
This defense is arguing for a lesser sentence, and the defendant in this case, Geoffrey Paschel, is expected to address the court. You won't miss a thing. We'll be right back here on Court TV, your front row seat to justice.
Okay, guys, so if I go on mute, that's because I'm going to be on a call. But I have this, I'm not going to turn off the live. So you can be here, but I have another 2 minutes before I have to jump in this conference call real quick, and it shouldn't take that long. Hi, everybody. Okay, I'm trying to see how long this is going to be. Oh, God. Okay.
Heidi, what do I need to have as far as I need to be prepared for this meeting? What do we need to have out?
Okay, guys, I'm here, but I'm on mute.
court to State versus Scott as it relates to the specific facts that are the predicate for the state's enhancement.
Hopefully we won't have any more breaks.
Submit mitigating factors to the court, which we have filed. Mr. Paschel, while in custody, has taken 30 classes as it relates to anger management and rehabilitation. I think that's relevant for the court to consider, even though we dispute very strongly the events that transpired on that evening that were the subject of this trial. Also, we would respectfully submit, again, that serious bodily injury is not appropriate under the offense for which he was convicted. The court, in determining the appropriate sentence, is confined to consider the evidence at trial, the pre-sentence report, principles of sentencing and argument as to sentencing alternatives, the nature and characteristics of the criminal conduct involved, enhancing and mitigating factors, statistical information, any statement the defendant wishes to make about himself, and any result of a validated risk assessment conducted by the Department of Corrections. We would respectfully say, and we appreciate the court's careful consideration as it relates to determining the appropriate sentencing range with the convictions out of the federal district court in the state of Texas, which we respectfully disagree with. But Mr. Paschel, as a range 2, is facing a significant sentencing range under Tennessee law of 12 to 20 years. If that conviction was not used as an enhancing factor, he would be range 1, which is a sentencing range of 8 to 12 years. Again, we do not want to deprecate or minimize any of the allegations that this jury found in the trial.
But that's what you're
beyond
doing.
a reasonable doubt as it relates to Mr. Paschel's conviction. But as it relates to serious bodily injury, in other cases, the court observed the proof and knows the extent of the injuries that were there. There are, and this is very significant, we had 2 series of photographs. One series was taken by first responders on that evening in June. Then a few days later, there was photographs which showed hematomas that were more pronounced, taken by Ms. Wilson. The medical records were not admitted in trial. There was no medical evidence or proof submitted during this hearing. And again, the major enhancement factor relied upon by the state is serious bodily injury. So if you take a legalistic, if you take an appropriate view pursuant to our sentencing schematic that the legislature has mandated, I would respectfully submit that there is no evidence that would rise to the level of serious bodily injury as it relates to prolonged unconsciousness. Because Ms. Wilson was able to testify in great detail as to what happened, in her opinion, that night when she took the stand. Without belaboring or giving examples of what the injuries could have been, the injuries are defined and limited by the evidence at trial. Those were defined by the photographs that were introduced. There was no further medical proof introduced this afternoon or at the trial. As the court is aware, these offenses under Tennessee law, the aggravated kidnapping, are severe. They require a 100% service rate. We would ask the court, based on the proof at trial, to sentence Mr. Paschel at the bottom of range 2, which is 12 to 20 years, to a sentence of 12 years. I think it's significant to know if the federal conviction was not used to enhance him to range 2 and he was range 1, the maximum of that range would have been 12 years. But in relying on the applicable factors pursuant to TCA 4035-210C2, we would respectfully ask that he receive a sentence of 12 years and that the court find that the state has not proven the enhancing factors and aggravating factors that they have set forth.
Thank you, Mr. Isaac. Mr. Paschel, in every criminal case before a court imposes a sentence in the state of Tennessee, the defendant is given an opportunity to address the court. It's called allocution. This is your opportunity to address the court if you would like to do so at this time.
We have just a moment.
Yes.
I'm dying to see if he addresses the court. If he's going to appeal, he shouldn't talk.
Your Honor, Mr. Paschel would like to briefly address.
He was just speaking to his client about the opportunity for allocution.
I'm a 44-year-old man. I have a lot of love left in me, a lot of hope. I have dreams still. I have a beautiful family. Beautiful friends. I'm a dad. Got children right there. I'm gonna be a grandfather here in May. I'm an uncle, I'm a nephew, I'm a son, I'm a grandson. I respect Miss Wilson Chapman. I respect Miss Moon. Miss Moon is the mother of my child. She's right, I haven't seen him in 5 years. I wish nothing but the best for them. Although there is a different circumstance of events that occurred, I still respect them. And I wish nothing but the best for them. As far as punishment, I'm punished and broken. There, I can rehab. Rehabilitation is a form of punishment, and I want to be better no matter what. I do have faults, but I want to be better. I want to be best at what I can be. And my focus is on doing that, whether it be, via my family or just be a better person all the way around. As you hopefully read in those letters, people have a common theme in that I go out of my way to help people. I don't need anything. I don't want anything. It just gives me that internal satisfaction to help people. That's my reward. So I ask that you have mercy on me. You have mercy on my family, my kids, and show me leniency in the sentencing so I can be a productive member of society and be back in their lives. Thank you, Reverend.
Thank you, sir. The court is called upon to impose a sentence here that is consistent with the purposes and principles of the Tennessee Sentencing Reform Act. And there are mandatory considerations that I must look at when imposing this sentence set forth in 4035-210B. Of course, I've carefully considered the evidence from the sentencing hearing, which included the pre-sentencing report.
I've listened carefully to the argument of counsel. Of course, I'm very familiar with the nature and characteristics of the criminal conduct of which Mr. Paschel has been convicted in this case. He is allocated, which I will consider, and I'm also considering the results of his validated risk and needs assessment as set forth in the PSI, indicating that he is a moderate risk with high needs in the mental health domain.
Jeffrey just said, I'm punished and broken to the judge. I can be rehabbed. I want to be better. That's my focus. You are not going to miss any of this judge's decision. That's up next when we come back.
Okay, I thought we were getting to that right now. Damn it. I'm still here. I'm here. I'm on break.
$4.49 now.
90-day fiancé Geoffrey Paschel in his allocution to the court said, I respect Miss Chapman and Miss Moon, the two victims who testified earlier today in a sentencing hearing. Right now, we are listening to the court as he delivers the sentence. Let's go back.
As I said, Mr. Paschel, like every human being, has good aspects, and he has some aspects here that we have seen that have been exposed that are very dark and are really evil. I know that I ruled that the letters of support are not properly in the record. I stand by that ruling. But I'm not surprised that Mr. Paschel will be able to convince friends, family, fellow citizens that he's a good guy, that he's an upstanding citizen. He's a handsome guy. He's charismatic. He has a job. He's also very image conscious. I'm not surprised at all that he projects an image outwardly to the world that he is this type of person. What we have seen here and what has been exposed in this trial is that what is going on behind closed doors is much different than the image that Mr. Paschel projects out to the rest of the world. As I've stated, this behavior towards these women is sick, it is sadistic, it goes beyond a desire to inflict physical harm on these women. It speaks of a deep psychological issue, I think, that Mr. Paschel has a desire to inflict as much emotional damage to these women as possible. The fact that he traveled to the state of Florida to sneak in the back door of Miss Moon's parents' home uninvited, engaged in aggressive sexual behavior following that intrusion. I think the record shows here that Mr. Paschel is manipulative, that he thinks, hey, just let me talk my way out of this. He thinks he can do that. I'm deeply concerned that he, after being found guilty, while in custody, was attempting to have a third party go see Ms. Chapman, again, unsolicited, at her home, in direct contravention of any order that this court has given him regarding contacting the victim in this case. And not only that, he was willing to use his children as a pawn in this illicit scheme to try to convince Ms. Chapman to come in here and speak on his behalf. That's disgusting, and he should be disgusted by that behavior. This court is. Mr. Paschel, sir, if you'd please stand. Jeffrey Ian Paschel in docket 116806, the jury having found you guilty in count 1 of aggravated kidnapping, a Class B felony. For the reasons stated, the court finds that the appropriate sentence in this case is 18 years to serve. You're a range 2 offender. This, of course, will be a 100% service rate. As to the misdemeanor counts in 2 and 3, the appropriate sentence in those will be 11 months, 29 days to serve. Those will run concurrently with the aggravated kidnapping in count 1. The pleas will be incorporated into the judgment, or pardon me, the jury's verdict will be incorporated into the judgment, and judgment will enter at this time. The cost, of course, will be assessed in this case, and judgment orders will follow. Can we go ahead and pick a motion for new trial date?
Yes.
I'll go a little ways out.
Okay, am I crazy? Or did I
the 30
just hear him
days.
go, this is 20 years?
Could we set it on
20 years. I had to lower my meeting and make sure I'm on
March
mute.
the 17th?
20 years. Yes. Stick it to him.
Judge, I do have a trial starting in here on Monday. That's an attempted first-degree murder that might go into that Wednesday.
Unfortunately,
Martin.
I'll be in Union County on the day.
Okay. Could we go to March 24th?
That should be good, Judge.
I'll be in a federal trial. I could have done it the next day, the 18th, or I don't know if the court.
Yeah, we are closed that day. Is that Good Friday? Oh, we're closed for some reason that day.
I anticipate my trial that starts the last week of March. In federal court's going to last 3 weeks, so.
Okay. So that put us in mid-April, you think?
Yes, sir.
Okay. What do you think about April the 14th?
Let's go for the state.
I have some things in Knox County. I'll make sure those get moved.
Okay, you sure? I mean, we can.
Yeah,
be
no, it's
flexible.
fine.
Okay, all right. Okay, April 14th will be the date for the motion for new trial. Of course, the time period to file that is within 30 days beginning today. I want to thank both of you. This was a difficult case, I know, for both sides. And I think both counsel conducted themselves very well and worked hard on the case, and the court really does appreciate that. Thank you all both. The court will be adjourned until 9 o'clock tomorrow.
Boil all that down, and this defendant, Geoffrey Paschel, has been sentenced to 18 years to serve 100% of that time on the 4 counts, including the aggravated kidnapping and the assault of his ex-girlfriend.
Okay, 18. I thought it was 20 when I heard 18 plus 11 and a half in this. Okay. Whoo, my God. Stop sharing. Guys, they're going to do a motion for a new trial because I guess he figures that he didn't get a fair trial. So April 14th, we're going to hear the stuff for the new trial. I am so excited. I haven't watched my damn show for tonight. I think I'm just going to recap this shit tonight. But yes. Oh, we got him. I'm sorry. Oh, my guys. Oh, my God. I thought it was 20 because he said 18, then he said 11 and a half, and then I'm in a meeting and I'm halfway listening. But okay, he's got 18 years, and he won't get any. He got to serve it straight. I love it. Wait a minute, somebody's birthday is April 14th. Okay, I got it, guys. Thank you for being here. I appreciate it. I love each and every one of you. And thank you. We had a great day. If you're around later on tonight, I will be recapping this probably because I don't think I'm going to get around to finishing up Married at First Sight. I started watching it. I haven't finished. I've been doing this all day and working. And I normally watch Married at First Sight in the morning when I get up, and then I watch the last hour at lunch. And as you know, for lunch, I've been sitting right here with you guys. Thank all of you for being here. Amber, that's 18 years, girl. 18 years. 18 years. And he deserves every bit. He should have got the full freaking 20. Now, his dumbass wants a new trial. Let's see if he doesn't get the full thing. Because now they know, now they know what the prosecution has. So now they see their hand. And you're dumb for trying to do something else. So, okay. I love you guys. Gotta go. Thank you. See you guys later. Bye.